May please, Your Lordship. Sir, I beg to mention an item of court number 13, madam.
Yes.
Court number 13 is not fulfilled. Item number 28.
What is your prayer?
Prayer is that, my lord, interim was there in the IA, stay was there. So, my lord, we have taken steps for a stay that can be
Notice,
extended.
notice to some. Notice both. Those matters are deferred.
Yes, but there is an urgency in this, my lord, because IA, my lord, stay was there till the next day. So next day, when it was left over, so we requested the registry to list this, my lord. And the execution case is fixed on 2nd of January, my lord. So,
Now,
my lord,
what is your prayer?
prayer is that, my lord, that can be extended, my lord, interim that stay may be extended till
But
the return.
unless the matter is before us,
My lord.
then this has to be,
Then, my lord, will fix it tomorrow, my lord. The IA,
okay. You give a mention memo.
my lord. Hello.
May it please your lordship. My lord, I am praying for listing a matter day after tomorrow, my lord. My lord, what had happened, your lordship was pleased to dispose of the civil division petition on 9th of December. And I have filed a miscellaneous case for modification of your lordship's order.
Okay, tomorrow, day after tomorrow.
I am deeply obliged.
Pursuant to my injunction matter, my lord, I have filed a petition, my lord. The lordship have prayed this new matter, my lord, kindly be taken up tomorrow, my lord, because the next date is fixed on 2nd January, my lord, 2025. And my lord, if injunction would not be, my lord, continued, but granted by the Solomon Court, my lord, my vote will be prejudiced.
Okay, tomorrow.
Lordship, in item number 10, I have filed an amended memo that is not on record, my lord. Maybe allowed. So, be not.
Item number 10, amended memo of appeal. Okay,
Another item, my lord, I have listed before court number 13 as motion. Item number 11 is a very urgent matter. I may be allowed to move this CRPIO at 2 p.m., my lord.
okay.
My lord, please, item number 32, my lord. I am the applicant in this case, my lord. Can it be listed after vacations, my lord?
Item number 32.
32, my lord.
Heard
32,
yes.
AB day.
Heard Mr. A.B. Day. Learned, you have informed the other
Yes, my lord, I have informed and taken consent also on the other side.
learned counsel for the applicant / appellant who prays for an adjournment on the ground of personal difficulty. He submits that he has informed the learned counsel for the respondent side, who has no objection to his prayer. Hence, the prayer is allowed. List this matter after Bihu vacation.
Deeply obliged.
My lord, my case CRPIO not been listed for orders. So kindly let the case be listed on 9th January.
Okay. Give a mention memo.
Deeply obliged, my lord.
May it please your lordship. Lordship, I beg to mention for listing an MAC appeal on 22nd of January, lordship, after vacation.
Or
Or hearing, lordship. Earlier in the month of October, we have mentioned what Honorable Court directed to submit an application before the registry, but registry did not listed that matter, lordship. After vacation, lordship.
after vacation on a date to be fixed by registry.
22nd, lordship.
No fixed date.
My pleasure. Lordship, I beg to mention a regular first step in order column day after tomorrow, Lordship. It's a partition matter between brother and sister. In spite of date of murder, they have not filed substitution application.
Okay.
May please, your lordships. My lords, I beg to mention item number 34. I pray for upgradation of the matter, my lords. My lords, this is an application and an MSc appeal for release of the part of the award.
Why upgradation?
My lords, I had mentioned Friday also this matter. The younger son of the applicant.
No, why you are praying for upgradation?
My lords, if it is not taken, it is on the end of the list today.
We'll take it up. 34, we'll take it up.
Obliged, my lords.
No upgradation.
Lordship, I am praying for listing of this motion matter for tomorrow, my lord, or tomorrow day after tomorrow, my lord, 2 CRPs, my lord.
When have you filed?
I'm on 16th, my lord.
Okay.
May it please, your lordship, I beg to mention an IA criminal for this alteration of one date in the order passed on 17/11, your lordship.
Passed by me.
Indeed, your lordship. IA criminal. NBW was recalled, your lordship, but the date and the case number were a bit erroneous.
Tomorrow.
Deeply obliged.
Yeah, please, your lordship. Lordship, I beg to mention for listing of a transfer application. I filed the same on 11/12. But it has not been listed till date.
Tomorrow.
Much older.
May it please your lordship, your lordship, with regard to item number 35, I pray for upgradation of the said item, lordship. Certain agencies, they are
Praise for, praying for,
upgradation.
why upgradation?
Lordship, is a,
You wait for your turn.
lordship, at the same time, I also pray for requisition of the objection filed by the other side. On the last date also, we have filed the requisitions, but objection has not been filed by them. But they have submitted that the objection has been filed by them. So allow me to file a requisition so that to bring on record the objection.
Objection filed by the other side.
Also, lordship, regarding RFF fresh matter, I beg to mention for listing on Friday, lordship. Motion made.
When have you filed?
I file on October, lordship.
Okay.
Lordship, beg to mention for listing of CRPIO on motion on 19,
On?
19, Lordship.
Okay.
of
I may appeal, Lordship. I beg to mention item number 3 of the court number 13 million. As per notification million, as per notice million, any urgent matter may be mentioned before this honorable court million.
What is the urgency?
Urgency million, the next date is 20th of the December million. Transfer petition million.
Tomorrow.
Tomorrow, item number 3 of this court number 13.
Tomorrow, give a mention, ma'am.
Yes.
May I please, your lordship? Lordship, with the consent of the other side, I would like to mention item number 30. Lordship, the matter may be fixed after vacation, lordship.
30,
Lordship.
30.
Yes, lordship. I have informed the other side, lordship. Consent has been taken.
Heard, Mr. What is the name?
W Hawk, lordship.
W. Hawk, learned counsel for respondent.
Yes, lordship.
Respondent who prays for an adjournment on the ground of personal difficulty. He submits that he has informed the learned counsel for the petitioner. What is her name? Also, Miss P. Day, learned counsel for the petitioner who does not have any objection to the said prayer. Hence, the prayer is allowed. Let this matter be listed after vacation.
Obliged, lordship.
May I please, with the consent of the respondents, I beg to mention item number 16, 17, and 18, which here are analogous matter. Matter will come up after the vacation.
16, 17, and 18. What is your name?
A Borua.
Heard Mr. A. Barua, learned counsel for the appellant who prays for an adjournment on the ground of personal difficulty. He submits that he has informed learned counsel for the
Yes, I have informed Lordship as Dr. Lalachin.
respondent who does not have any objection to the said prayer. Hence, the prayer is allowed. List this matter in the next year on a date to be fixed by registry.
Much of it.
May you please, your lordship, I beg to mention listing of MSA appeal for order after vacation.
Okay.
May it please, your lordship. Lordship, I beg to mention item number 19 of court 13, lordship. Analogous matter will be listed on Thursday. It was ordered, lordship, on 15th. RSA 216 of 25. It may also come, this matter also may come together, lordship.
Give a mention memo.
For clarification, I have mentioned regarding one item regarding court number 13 to be moved at 2 p.m. Whether your lordship is allowed or bench assistant is regarding some confusion arise. Motion matter, very urgent matter.
Urgent matter.
2 minutes.
Have to- Okay.
May I please, your lordship, I beg to mention for listing a MSC appeal, press case, lordship. In this case, I am the owner and exhibition also file, fix it on Friday, lordship.
Okay.
Obliged.
Yeah, please, lordship, I beg to mention item number 8, lordship. Lordship, there is a notification 32, lordship. As per notification, the bail application arise out the same affair which filed in the Guwahati High Court are to be listed before the same honorable court who has previously disposed of bail application, lordship. Lordship, there is co-accused Rakesh Ahmed bail rejected by honorable Justice Anjan.
Why it has been listed before this court?
Lordship, this was written before this honorable court. Dismissed on withdrawal by this honorable court.
Registry to verify and list.
But if it is withdrawn or either rejected or disposed.
Who has disposed of the Rakesh Khan's case?
Yes, Ahmed,
Court number
Oh,
20.
court number?
Justice Anjan Moni Koliki.
Let the registry verify and heard Mr. M. Rahman, learned counsel for the petitioner, also heard Ms. N. Kakoti, learned counsel for NCB, who submits that a a coordinate bench of this court has rejected the bail application of
Co-accused.
one of the co-accused, and hence, as per notification number
Bail application number.
notification number
32.
notification number 32 of this register dated 13/5/2020
30 Lordship.
30. Speak the tell me the date.
13 May
Yes.
30 Lordship.
Which year?
24 Lordship. 20.
Dated 13 May 2024. This case ought to have been taken up by the same bench which rejected the bail application of the co-accused. Stop. Registry to verify the same and list this matter before appropriate bench on.
My part also mechanically noted. It was withdrawn by this honorable court Lordship.
On the other hand, Mr. M. Rahman, learned counsel for the petitioner, submits that since this bail application since the present petitioner had earlier withdrawn the bail application filed by him and withdrawal was allowed by this court, this bail application may be taken up by this court. Stop. Registry to withdraw, registry to verify the facts and list this matter before appropriate bench on day after tomorrow.
Obliged.
Yes.
Commercial chartered case Lordship and this case Lordship, I have taken the ground Lordship. Provision under section 36 of BNSS violation is for Lordship
36, what 36 violation?
of BNSS Lordship. So at least one witness is required to be attested Lordship.
So whether it entitles you to get bail?
Lordship, I have the judgment Lordship DK was which is a ratio Lordship. I have the judgment Lordship. Want to refer-
No, sir. Whether 36 is mandatory, whether it overcomes the embargo of section 37.
It's mandatory in national Lordship, which is already been guideline by the Supreme Court of India Lordship.
No. Whether it entitles you to get bail on that ground.
As per, if the arrest is illegal Lordship, as per the guidelines in the DK Basu case Lordship, if its violation is there Lordship, the arrest will be illegal Lordship. May I read Lordship?
Read it. Okay, suppose that this attestation by one witness is not there, whether it will entitle you to get bail, whether it will overcome the embargo of 37.
Overcome 37 because
That is your submission. Is there any authority to support your submission?
Lordship, as per, this is fundamental rights also Lordship, which has been violated Lordship, because it's already been DK Basu guideline is there Lordship, and I am supporting one coordinate bench order Lordship.
What fundamental right has been violated?
Control Lordship. which is guideline by the Supreme Court, Lordship. I'm referring on order of coordinate bench, Lordship. On that basis, Lordship, on accused person was enlarged on bail, Lordship, and on in different cases, Lordship. Para 8. The ratio laid down in the case of D.K. Basu, Ashok Kumar Johari versus State of West Bengal reported in clearly lays down that the police personnel carrying out the arrest and handling the interrogation of the arrestee should bear accurate, visible, and clear in identification and name tags with the designation. The particulars of all such police personnel who handle interrogation of the arrestee must be recorded in a register, and that the police officer carrying out the arrest of the arrestee shall prepare a memo of arrest at the time of arrest, and such memo shall be attested by at least one witness. And para number 9, in view of the aforesaid
Where is the memo of arrest?
memo of arrest, Lordship, in case number 51, Lordship. 51 and 52, Lordship. There is no attestation of witness, sir. At least one witness to be attested. That is not there.
Section 36, is it mandatory?
I think it's a procedural error.
But a coordinate bench has held that it is mandatory.
So I have to go through. Lordship, unfortunately, I do not have a copy of the petition also, Lordship. The office must have misplaced it. They must have served it, Lordship. I'm not done that. And this aspect, Lordship, I was under the impression of they were placing reliance on 47 and 48, which is
No.
not complied with. But
Whether 36 is mandatory.
I will have to go through it, Lordship.
Because if we agrees with the coordinate bench, then
Yes. I
he
have
has to be given bail.
I have to go through it, Lordship, because
When?
in IPC offences, probably, Lordship, but NDPS, Lordship. there
Yes,
are-
that is my query.
there are-
Whether violation of 36
Yes.
overcomes the embargo of section 37 of the NDPS Act. This is my query.
Understand, Lordship.
In DK Basu, in all cases, Lordship, I'm reading, Lordship. We therefore consider it appropriate to issue the following requirements to be followed in all cases of arrest or detention till legal provisions are made in that behalf as preventive measures. And here in number 2 point, that the police officer carrying out the arrest of the arrestee shall prepare a memo of arrest at the time of arrest. Such a memo shall be attested by at least one witness, and thereafter who may be either a member of the family of the arrestee or a respectable person of the locality from where the arrest is made.
No, suppose there is a violation. Which right is violated? Article 22 is not violated because Article 22 is regarding informing you about the grounds of arrest. Grounds of arrest were informed. If Article 21 is violated, in what manner?
Personal liberty, Lordship, in the coordinate bench order, Lordship, para number 9. In view of the aforesaid ratio laid down by the Honorable Apex Court, which actually deals with the personal liberty granted under Article 21 and 22 of the Constitution of India. This court is of the considered opinion that there is a violation of the section 36 of the NSS, which is mandatory in nature, and that makes the procedure of arrest as illegal, providing the right to the accused applicants to be released on bail, though the contraband materials so seized was much more than commercial quantity.
The observation of the coordinate bench is not binding. This court may differ also. But before that, I want to more assistance from both of you
To go to the DK Basu.
and go through this. We may agree also with the observation of the coordinate bench. You also go through this judgment.
Lordship, may I request him to give me a copy of the petition, Lordship?
Yes, day after tomorrow, last day. No, let him get some time. Because then it will be law. Heard, Mr. What is your name? Ms. Hussain, learned counsel for the petitioners. How many petitioners are there?
Two.
Petitioners. Also heard Mr. B. Sharma, learned additional public prosecutor. The learned counsel for the petitioners submits that in the instant case, while preparing the arrest memo at the time of arresting the petitioners, no signature, the arrest memo was not attested by independent witness as mandated by the Apex Court in the case of DK Basu versus State of West Bengal, reported in 1997 1 SCC/1 SCC, page 416. Learned counsel for the petitioner submits that the requirement of attestation by at least one witness of the memo of arrest prepared by the arresting authority at the time of arrest is a mandatory requirement, and any violation of such mandatory requirement would override the embargo of Section 37 of the NDPS Act. In support of his submission, he has cited a ruling of cited an order of the coordinate bench in bail application number 3636/2025 within bracket order dated 2/12/2025. Stop. Learned additional public prosecutor has submitted that he is not having the copy of bail application and prays for request directing the petitioner to furnish a copy of bail application. He also submits that some time may be given to him so that he can go through the judgment cited by the petitioner, cited by the learned counsel for the petitioner, and may make his submission thereon. The prayer is allowed.
Sincerely, can it be on the reopening day, Lordship? First day of the reopening day? Because these 2 days will be a little bit difficult for us. Immediately on the reopening day.
Before vacation, Lordship, any day, Lordship. I don't have any other thing regarding this. But after vacation, it will be very late. Already TCR received, Lordship.
No. Friday. Let this matter be listed again on 19th of December.
Published.
7.
May I please your lordship? My senior is on legs, so this matter may be taken up for some time.
Then Lordship, this service report is still awaited. Office note dated 12/12/25.
Proxometer,
Also,
you find out whether charge sheeted case. Heard, Mr. What is your name?
HR Khan.
HR Khan, learned counsel for the petitioner. Learned additional public prosecutor, also heard Mr. B. Sharma, learned additional public prosecutor, who submits that though the Though the scanned copy of the trial court records have been received, however, the service report in respect of respondent number 2 is still awaited. Stop. In view of the submissions made by learned additional public prosecutor, he is requested to get information regarding fate of the notice issued to respondent number 2, from the officer in charge of the jurisdictional police station, and let this court know about the same on the next date fix. Let this case be listed on before Bihu vacation, 9th of January.
Lordship, interrogation and date, Lordship.
Nine January. Nine, Lordship, we have received the report of service.
It is also a POXO matter. We'll appoint one amicus.
Anything, Lordship, this, to my information, Lordship, this was served on Saturday, last Saturday. Upon the respondent, Lordship. So I leave it to Lordship.
But no one has appeared. We appoint one amicus. Heard. Mr. What is your name? MS Hussain, learned counsel for the petitioner. Also Mr. B. Sharma, learned additional public prosecutor, who submits that the notice issued to respondent number 2 has been served. Stop. However, as no one has appeared for respondent number 2, this court proposed to appoint one amicus curiae.
Last time, Lordship, Mr. Sarfaraz Nawaz appeared, Lordship.
He is in the list. Yeah, okay.
Last time he appeared.
Stop. One amicus curiae to defend the cause of respondent number 2 in this case. Accordingly, Mr. S. Nawaz, learned counsel, whose name appears in the list of amicus curiae prepared by the registry of this court, is hereby appointed as amicus curiae to defend the cause of respondent number 2 in this case. The petitioner shall furnish a copy of bail application along with annexures to the newly appointed amicus curiae. The registry shall reflect the name of Mr. S. Nawaz in the cause list as amicus curiae for respondent number 2 henceforth. Let this matter be listed 7th of January.
Deeply obliged.
This was nothing.
Item 41. Item number 31.
This was nothing.
Also, item number 1. Item number 1.
After something.
In this case, my name has not been shown, my lord, and I have not received a copy of CRP, although I had appeared in IA.
I is for
A notice of delay, which was subsequently withdrawn because that is not applicable in the present application. We filed under Article 227 of the Constitution.
now what is to be done?
Is for the Malan, calling for the petitioner.
Yes.
Maybe they had to furnish the copy, Malan.
Matter will be listed thereafter by showing my name.
My lord, I will,
Heard Mr. R.K. Moore, learned counsel for the petitioner. Also heard Mr. Ain Alam, learned counsel appearing for all the respondents. This application under Article 227 of the Constitution of India has been filed by the petitioners, by the petitioner impugning the order dated 22/6/2023, 6/7/2023, and 11/8/2023 by the Court of Learned Civil Judge Junior Division number 4, entitled suit number 151/2020. What was prayed for, what was ordered by the impugn orders?
My right to call for the NJK, Miss NJK records were
Whereby the prayer for calling of Sir Miss NJ cases from the office of Civil Judge Junior Division number 4, Kamrup, was rejected by the trial court.
Junior Division number 1, my lord.
Number 1 was rejected by the trial court. Learned counsel for the respondents has submitted that he has not received the copy of revision petition and therefore prays for directing the petitioner to furnish the same. The learned counsel for the petitioner undertakes to furnish the copy of revision petition to the counsel for of the respondent during the course of the day.
I have received.
When
Just now.
now you'll be filing any objection?
My lord, I'll file objection.
Learned counsel for the respondents prays for some time for allowing the respondent to file written objection in this case. Let this matter be listed on 27th of January. At what stage this suit is pending?
Evidence of DW, my lord. C22, 3 years have been passed, my lord, only for NJK record. This is an Egyptian suit, my lord. This is pending for NJK records for last more than 3 years.
The suit has been stayed.
No, my lord. No stay has been granted, my lord. That has been proceeding for filing evidence on DW.
And the petitioner is the defendant.
Defendant is the suit, my lord.
Okay.
Defendant, my lord, in the suit.
I did it.
No, why you're resisting the calling of,
No, my lord, I am not resisting. Court has rejected your lordship, I cannot see.
on what ground?
Page 67, your lordship, I cannot see. Page 67 of their application.
On what ground?
Page 66, my lord, annexure 6. Page 66, my lord, annexure 7. This is the ground, my lord.
Oh, you have not taken steps.
My lord. This is the reason, my lord.
Before that, my lord, page 65 may be. Online copy reflects that matter is fixed for DWNJ record, but in the next purpose is defense witness only. The order does not reflect that it is for the I have to take steps. And in the actual order, that is at page 64. The
Page
full order.
63 type copy of 64, my lord. Page 63 may can be seen, my lord. Specifically, this matter was posted for evidence for DW and calling for NJK records. On on the day, my lord, on 22/6/23, defendant present before this, before the land trial court. And file petition number so and so.
No, his prayer for calling of NJK's records was allowed or not?
That one allowed, but I have to directly to take steps. But the steps I am unable to take because of the online copy. I cannot know that I have to take the steps.
Your lordship kind of see in the online also DWs and NJ records.
This
How
is
NJ record will place before the trial court, my lord.
Next
Until unless
purpose.
he takes steps.
Next purpose, your Honor. Defense witness only.
What steps he is required to take?
So he is to give a requisition, my lord.
Already
Noting the AJ case records which he intend to call for from the office of Civil Judge Unit Division number 1 in Guwahati.
That has to be mentioned in the
Mentioned in the-
orders itself, calling for the records.
No, my lord, that
Yeah.
is already, this is in continuation, my lord. Already he has filed this application, my lord. Some part of the NJ case record has been placed before the court and some other part has not been placed. So he is to identify which have come up before the court and which have not.
In
come
his
up.
application itself, he has to mention.
My lord.
my lord, I have mentioned in the page number 62, the requisition was issued on 24/5/23. Requisition for NJK record issued by the memo number 288 on 24/5/23.
In page number 62 also, my lord, this has been reflected. It is seen that
Oh, okay. You file objection, we'll hear it on that day. Let this matter be listed on 27.
can be prior, my lord, prior,
Before,
before the.
8th of January.
Item 48 from supplementary list.
So this is an application filed under section 24 of CPCD lordship seeking transfer of title to divorce from the court of Gwalbara to family principal just family court, Kamrup Metro lordship. This matter was listed yesterday, but lordship, but what had happened, the last in court number 13, court has asked me to place the last order lordship, but since the date was on 27/11/2025 in Gwalpara court, but the next date is not shown, neither the order has been uploaded lordship, so certified copy could not be produced lordship.
Where do you stay?
I stay here in my parental house lordship in Panjabari, Guwahati, along with my minor children lordship,
Where the marriage was performed?
from Kamakhya lordship, in Kamakhya temple in Guwahati. I have mentioned lordship,
And where you last resided with your husband?
lordship in her matrimonial house in Gwalpara lordship. And since
What is the ground on which you are seeking transfer?
lordship, she is receiving a minimum maintenance of lordship 5,000 rupees lordship, and she is also having a minor child lordship, and lordship, I have also mentioned in page number lordship. Page number 5 lordship.
You are
point number 7,
unemployed.
lordship.
You are unemployed.
Yes, lordship.
Heard, Mr. What is your name?
R. Chetri.
R. Chetri, learned counsel for the petitioner. This application under section 24 of the Code of Civil Procedure, 1908 has been filed by the petitioner, Srimati Rekha Rani Rabha, praying for transfer of title suit within bracket divorce case number 61/2024 filed by the respondent within bracket husband before the court of learned additional district judge Gwalpara to the family court at Kamrup Metro. Family Court Kamrup Metro at Guwahati. Learned counsel for the petitioner has submitted that the petitioner is presently staying with her parents and a minor's child in her maternal home. He further submits that the petitioner is unemployed and is dependent on the monthly maintenance allowance of 5,000 which has been allotted to her, which has been granted to her. Stop. He further submits whether case is still pending or it is disposed of.
No, it's still pending. Still pending. Lordship, please.
The issue notice to the respondent. The petitioner shall take steps for issuance of notice upon the respondent by registered
Till
post
disposal of this instant.
as
petition,
well
Lordship.
as by usual mode within 7 days of this order returnable after 4 weeks. Stop. Considering the in the meanwhile, considering the submissions made by learned counsel for the petitioner as discussed in the foregoing paragraphs, further proceeding of title suit divorce number 61/2024 pending before the Court of Learned Additional District Judge Gwalpara shall remain stayed till next returnable date. List accordingly.
I'm obliged.
May it please respect. This present civil litigation arises essentially in order, madam, from my application under order 14 rule 2, madam, for framing preliminary issue that was rejected, madam. Now, madam, what has happened in this case is that
Who is appearing for the this?
respondent service is complete, madam. We have taken justice service also, we have filed affidavit also, but they have not appeared.
We'll direct this to proceed ex parte. Your interim relief is there.
Interim is there, madam.
Interim is there. We'll continue the interim. Heard Mr. Iqbal, learned counsel for the petitioner. No one has appeared for the respondent. Though the notice issued to respondent number 1, 2, 3, and 4 have been duly served. Stop. This civil division petition is therefore this civil division petition therefore shall proceed ex parte against the defendant. Let this matter be listed after 3rd of February. Let the interim order granted earlier shall continue till next date.
Obliged.
My pleasure.
Yes.
Okay, during this matter, the respondents have although appearing from the date of first listing being caveated, but on last occasion, they have raised a question.
Of maintainability.
Maintainable. That the petition is maintainable under 227 of Constitution of India.
Yes. More.
Lordship,
This is a challenge to an order passed in appeal under Order 43,
Rule 1.
Rule 1R.
Initially, Learned Trial Court granted injunction in my favor.
And the
Thereafter-
appellate court vacated the injunction,
Yes.
set aside the.
But after full submission, I have rightly referred this case under 227 of Constitution of India. In this regard, Lordship, I want to place judgment of Honorable Supreme Court and another judgment of Calcutta High Court. First, kindly take up, Lordship, the judgment passed by Honorable Supreme Court.
Yes.
Yeah, in this particular citation to the report on the Supreme Court election.
Suryadev Rai.
Lordship,
Yeah.
in this particular question, the similar question was raised by the opposite party. And the Honorable Supreme Court, only on this point, this judgment was passed.
Yes.
Similar question. Because Lordship, after amendment of 2002 CPC, the power of revision under 115 was curtailed, and then the power under 227 was enhanced, Lordship. That is categorically been discussed in this judgment.
No, why you have not preferred revision under 115?
This is not maintainable, Lordship,
Why?
on the basis of this judgment. That has been
Because
discussed
that
in the-
order is a final order.
No, Lordship. This is not final. Any order passed against under Order 39 Rule 1 and 2 is not final order. In view of principle laid down under Section 141 of CPC.
No.
So
The order passed in a,
all miscellaneous case, Lordship, falls under Section 141, being part of main suit. It's only
no, but that order has disposed of the appeal. Finally disposed of the appeal.
that has been
The
discussed in,
impugn order has finally disposed of the appeal.
yes,
You are saying that still it is not a final order.
yes. Lordship.
How?
Under the purview of 141, that has been categorically discussed in Calcutta High Court judgment. And why not 115, 227, that has been discussed in this Supreme Court judgment.
Show me.
So kindly first peruse paragraph 225 for better understanding of later part of the judgment, Lordship. May I read, Lordship, from paragraph 2? I
Yes.
also only relevant part.
No, in the instant case, you have to show that order passed in an appeal under Order 43, Rule 1R is not a final order.
Yes, that has been discussed, Lordship.
Where? Come directly to that. Okay, what you want to show in para 2, 3 and 4?
Exactly similar point, Lordship. And very unfortunately, that judgment is not reported in SCC or an AIR. That is why, Lordship,
Suryadev has been reported in SCC.
no, Lordship. If I am not mistaken to my limited
No,
understanding.
it is.
Maybe.
Okay,
May I read, Lordship?
yes.
Academically, very interesting judgment. The appellant filed a suit for issuance of permanent preventive injunction based on his title and possession over suit property, which is a piece of agricultural land, in the court of civil judge. He also sought for a relief by way of ad interim injunction under Order 39, Rule 1 and 2 CPC. The prayer was rejected by the trial court as also by the appellate court. Feeling aggrieved thereby, the appellant filed a petition so-and-so in the High Court, labeling it as one Article 226 of the Constitution. The High Court has summarily dismissed the petition, forming an opinion that the petition was not maintainable as the appellant was seeking interim injunction against private respondent. Reference is made in the impugn order to full bench decision of Allahabad High Court in Gangasaran versus civil judge Hapur, Ghaziabad and others. Earlier, the remedy in final civil revision under 115 of the CPC could have available by any appellant therein, but that remedy is not available to the appellant because of the amendment made in section 115 in the CPC by amendment with effect from 1/7/2002. Then the appeal raise a question to frequent occurrence before the High Court, as to whether the impact of amendment section 115 of the CPC brought by Act 46 of 99 with effect from 1/7/2002 on the power and jurisdiction of the High Court to entertain petition seeking a writ of certiorari under Article 226 of the Constitution or invoke the power of superintendence under Article 227 of the Constitution as against similar order, act or proceedings of the court subordinate to high courts, against which earlier the remedy of filing civil revision under section 115 of the CPC was available to the person aggrieved. Is an aggrieved person completely deprived of the remedy of judicial review if he has lost at the hands of the original court and the appellate court, though a case of gross failure of justice having seen an occasion can be made out. Section 115 of the Code of Civil Procedure as amendment does not now permit a revision petition being filed against an order disposing of an appeal against the order of the trial court, whether confirming, reversing, or modifying the order of injunction granted by the trial court. The reason is that the order of the High Court passed either way would not have the effect of final disposing of the suit or other proceeding. The exercise of revisional jurisdiction in such a case.
No. The injunction application would have been finally disposed of.
That I will show from next judgment of Calcutta High Court.
Okay. But Supreme Court observed that the reason that it would not have effect of finally disposing of the suit, it is okay, or other proceeding.
Yes, in later part, Lordship will find against order passed under Order 41 Rule 1 or 1, 2 to 27 is exactly applicable. Okay. The exercise of revisional jurisdiction in such a case is taken away from proviso inserted under subsection 1 of section 115 of the CPC. The amendment is based on the Malimat Committee recommendations. The committee was of the opinion that the expression employed in section 115 CPC, which enable interference in revision on the ground that the order of allowed to stand would occasion a failure of justice or cause irreparable injury to the party against whom it was made, left open wide scope of the exercise of revisional jurisdiction with all types of interlocutory orders, and this is substantially contributing towards delay of the disposal of cases. The committee did not favor denuding the High Court of the power of revision, but strongly felt that the power should be suitably curtailed. The effect of the erstwhile clause B of the proviso being deleted and a new proviso having been inserted is that the revisional jurisdiction in respect of an interlocutory order passed in a trial or other proceeding is substantially curtailed. The revisional jurisdiction cannot be exercised unless the requirement of the proviso is satisfied.
Okay.
Then next paragraph.
Now you show that an order passed in an appeal under 43(1)(r) is an interlocutory order. Only that much.
Sometime after this thing of remaining part of the.
Yes, yes.
Definitely, that point is there in Calcutta High Court judgment. Next paragraph 5. As a preclude to search for answer to question posed, it become necessary to recollect and restate a few well-settled principles relating to constitutional jurisdiction conferred on the High Court under Article 226 and 227 of the Constitution in the backdrop of the amendment section 115 of the CPC. Then if your lordship kindly peruse next page 21, here what is the duty of the Honorable High Court under 227 that has been discussed in paragraph 21.
Okay, let us skip that.
Yes, lordship. Then lordship, paragraph 28. Paragraph 28
Okay,
here.
that also,
That's the amendment section one.
that I agree. That suppose in case of interlocutory orders, High Court has the jurisdiction under Article 227.
This is actually, this is not interlocutory order. This particular case discussed against final order. Passed against order 41 rule 1R. That has, I have shown.
In this
paragraph
para,
two.
28.
Yes, lordship. No, young lordship, paragraph 2, it's against final order.
Yes.
Against final order, lordship, similar to my case, lordship. The only one confusing, lordship, we are understanding that any order passed by appellate court or trial court under order 39 1 and 2 or order 41 rule and 2, we think that this is final order.
Final order.
Actually not final order.
What is there to show that?
Yes, next judgment, lordship. Then finally, lordship, ultimately a discussion is here in paragraph 28. Why not 115, only 227? That has been discussed in paragraph 28. And then finally, lordship, page 31. Some references there of other decisions also. More particularly 32 paragraph. Then in paragraph 37, sub 4, why 227 lies, that has been discussed. And finally, in paragraph 39, the Honorable Supreme Court held that yes, against any order of order 43 rule 1R, 227 is maintainable, not 115.
Read 39.
Before 39, if your lordship kindly peruse 37 paragraph 4.
Yes.
Page 14. Supervisory jurisdiction under Article 227 of the Constitution is exercised for keeping the subordinate court within the bound of their jurisdiction. When the subordinate court has assumed a jurisdiction which it does not have or has failed to exercise a jurisdiction that I have seen shown in my application, revision application as a ground lordship, which does not have, or the jurisdiction though available is being exercised by the court in a manner or not permitted by law, and failure of justice or grave injustice has occasioned thereby, the High Court may step into exercise its supervisory jurisdiction. Then paragraph 39, that appeal is allowed. The order of High Court refusing to entertain the petition filed by the appellant holding it not maintainable is set aside. The petition shall stand restored on the file of the High Court to be dealt with by appropriate bench consistently with the rules of the High Court, depending on whether the petitioner before the High Court is seeking a.
You show the Calcutta High Court judgment.
Only difference is there. Here, the plaintiff side for first time filed application under order 39 rule 1 and 2 before district judge. Lordship will find that in paragraph 2 subpara highlighted portion. Here, court decided whether having regard to facts and circumstances involved in this revision application, an appeal is maintainable against impugned order under order 43 rule 1R of the CPC of the court or not. To decide that part, lordship, the Calcutta High Court here referred all provisions relating to appeal from orders. In next page, Lordship will find the Calcutta High Court in paragraph 4 to decide all the this question. Here referred section 104. Section Lordship knows order from which appeal lies. That raise 114, then 105 other orders, then 107 power of appellate court, then 108, then miscellaneous proceeding, 141. So before coming to next part, if your Lordship kindly peruse for a moment section 141 of the CPC, what section 141 says. All miscase is to be processed under the purview of Lordship 145. Section 141. How to proceed a miscellaneous case in main suit that has been Lordship, that principle has laid down in section 141. If your Lordship kindly peruse section 141 before coming to next part of
No,
the.
what you want to emphasize?
Any order passed in miscellaneous proceeding,
Is an interlocutor.
yes, is an interlocutor.
Where is that?
Lordship,
What
one
is the
principle
base?
is there, one principle is there. Interim order always merge with final order. Here court will decide at best injunction order on in the purview of permanent injunction. If Lordship
Okay.
case is disposed of against the plaintiff, then definitely that interlocutory order will not be there.
So your submission is that any order passed in a
Any miscellaneous
proceeding
case-
under 141
Yes,
is a
or
interlocutory.
interlocutory order, not final order.
And against such order, 227 lies,
Yes, Lord.
not 115, there is a bar in proviso.
Yes.
Okay.
Kindly peruse section 141, miscellaneous proceeding. In some miscellaneous cases are there, Your Honor knows very well, particularly order 39, rule 1 and 2, order 9 application. In fact, evidence is to be adduced, Lordship, in some miscellaneous cases. That is under the purview of section 141 of the CPC, Lordship. May I read, Lordship, section 141?
Yes.
Miscellaneous proceeding. The procedure provided in this code in regard to the suit shall be followed. The procedure provided in this case, in this code, in regard to suit shall be followed. The proceeding of suit and the proceeding of miscellaneous case must be similar, Lordship, as far as it can be made applicable in all proceeding in any court of the civil jurisdiction. So procedure of the suit and procedure of the miscellaneous case must be similar. Where necessary, Lordship. It is not mean that in every against every application, court will direct the petitioner to adduce evidence. But normally that procedure of suit and procedure of miscellaneous case must be similar.
Now, where is that observation of Calcutta High Court that?
Lordship, here, after putting that miscellaneous proceeding, here in onwards, Lordship, paragraph 16, the scope and purview of 141 has been discussed, Lordship. Paragraph 16.
No,
onwards.
141 is a different matter. It only relates to the applicability of procedure in case of suit to a proceeding, miscellaneous proceeding,
All miscellaneous.
all
proceeding.
miscellaneous
This
proceeding.
is also miscellaneous proceeding, Lordship.
So it relates to what procedure would be applicable. We are on a different question. We are on a question that whether an order passed in an appeal under order 43 rule 1R is an interlocutory order.
Yes, that is my humble and respectful submission, Lordship. Since order 39, rule 1 and 2 also falls under the purview of section 141, that is why that is not the outcome of order 39, rule 1 and 2 is not final outcome. Being it is a part of the suit, Your Honor. Only protective order can be passed.
Yes, yes.
Only to
Yes,
preserve,
Mr. Sharma.
preserve subject matter of the property, Lordship.
Lordship, I have searched his case law. Radhesham, sorry. No. Surjara Debrai versus Ramchandra Rai. That is reported in 2000.
His submission has force.
Lordship, I am just coming to that. So once I searched this case law, I found that there has been overruled by the Honorable Supreme Court in Radheshyam versus Sabinath. So he's relying on a
No, no,
overruled judge.
Overruled.
I have searched the Supreme Court today, and once I opened that case law, it is shown that the judgment has been overruled by Radheshyam versus Sabinath. So on this point, I have to verify the case law also of Radheshyam.
No, listen, we are on a very limited question that whether an order passed in an appeal under Order 43, Rule 1R of CPC is a final order or an interlocutory order. In Suryadev Rai, at para 4, Apex Court has held that it is an interlocutory order and 115 is not maintainable.
That-
Now, if it is overruled, then you have to assist me.
Yes, Lordship. I have to
You find
take the
out.
case law also, I have to study it. And since also it is very clear, it has been written in the red mark, red color.
No,
This will-
don't go by red mark. Read the judgment and see.
So, I will go to it, Lordship.
Maybe at two, Lordship. Otherwise, the injunction matter is very urgent, Lordship. If your Lordship. kindly
What
tell-
was the injunction
Filed in the
granted?
month of June.
Injunction was granted in my favor, restraining them to use the banner of the petitioner number 1 union, Lordship. So after sentence aside that injunction order, they are continuously doing various illegal activity under the name of petitioner number 1 union. They are outsider, Lordship. They have no qualification even to.
No, we will take it up tomorrow or day after tomorrow,
They have to-
along with the question of maintain
In this
Tomorrow, Lordship.
tomorrow.
Calcutta.
Tomorrow
High
you
Court-
go through that judgment. Which
Definitely,
judgment?
And in
Which judgment?
Calcutta High Court.
Sabinath versus, sorry, Radheshyam versus Sabinath. It is reported in 2003, 675.
Heard Mr. R. Ali, learned counsel for the petitioner. Also heard Mr. B. Sharma, learned counsel for the respondent. Learned counsel for the petitioner has submitted that an order, the petitioner has preferred this instant revision application under Article 227 of the Constitution of India, impugning the order dated which order?
Lordship,
Impugning the order dated
17/12/2024.
17/12/2024. Passed passed by the Court of Learned Civil Judge Senior Division Number 1, Kamrup Metro in this was passed by, in which case?
This was first Lordship,
miscellaneous
Appeal 1 of 25.
1 of 25.
In Miss Appeal number
1 of 25.
1 of 25.
Order dated 25.
Sorry, Lordship.
17/12 is not the order.
Not, just judge order passed by trial court. 28/5/2000.
Cut it, 17/12 or Jagat. 28,
5/2025.
2025. Passed in Miss Appeal number 1 of 25. Learned counsel for the petitioner has submitted that the said appeal was preferred by the respondent side under Order 43, Rule 1, within brackets small r of the Code of Civil Procedure. He further submits that an order passed by the appellate court under Order 43, Rule 1 within bracket R of CPC is an interlocutory order and therefore proviso to section 115 of the CPC bars any revision under the said provision. He submits that in such cases, the remedy of a revision under Article 227 of the Constitution of India is available to the aggrieved person. He further submits that in the case of Surya Dev Rai versus Ramchandra Rai, reported in, you have SEC citation
Yes, sir.
reported in
2003, 6 SCC 675.
2003 6 SEC 675. The apex court has held that an order disposing of an appeal against the order of a trial court, whether confirming, reversing, or modifying the order of an injunction order, is not amenable to revision under section 115 of the Code of Civil Procedure 1998. He submits that such an order can, however, be challenged under Article 227 of the Constitution of India. On this, learned counsel for the respondent submits that the ruling cited by the learned counsel for the petitioner has been overruled by the apex court in the case of
Radheshyam versus Sabinath,
Radheshyam versus Sabinath,
2009 5 SCC.
reported in 2009 5 SCC
616.
616. On this, learned counsel for the petitioner submits that he may be granted some time to go through the said ruling and make his submissions before this court. When tomorrow, let this matter be listed again tomorrow at 2 p.m. If it is maintainable, you may make submission
On merit.
on merit.
That's it.
If it is
Yeah,
not,
I have the reply for that, for their submission.
okay.
They don't have any case. There is no primary case.
Okay, wait till tomorrow.
Shall satisfy your lordship if necessary.
Okay.
Obliged.
May I please?
Yes.
My lord, we have, my lord, challenged the interlocutory order that your lordship will find at page 45, annexure 5, my lord.
Lordship, in this case, Lordship sole respondent already died, Lordship on 9/12.
Who died?
Sole respondent.
He expired.
Nine, just local. 9/12, Lordship, 2020.
9/12.
2025.
Oh, recently. You take appropriate step and decide whether to pursue with this case.
Yes, that has to, my lord, ultimately his legal heir has to be, my lord, made.
You decide accordingly.
Now, my lord, only problem is there, my lord, because of this, my lord, interlocutory order, we are restrained to harvest the, my lord, paddy, which is cultivated by us. All the rice, my lord, are repaid. And, my lord, part of the land, we are having residential house numbering 25s. So this injunction order ought to have been granted against the person who executed the sale deed. But those persons, very cleverly, my lord, are not made party respondent in the proceeding.
Where is the
Yes, lordship kindly see.
impugn order? No, but if the respondent has expired, against whom we will pass orders?
Yes, that's true, but lord, we have to, my lord, make party. But page 45, lordship kindly see the impugn order. And operative order, lordship will find at page 50. second paragraph, my lord. Page 52nd paragraph. Page 52nd paragraph, my lord. Under such circumstances, it would be in the interest of justice that the temporary injunction is granted. Thus, the opposite parties are restrained from entering into the suit land or alienating or changing the nature and feature of the suit land till disposal of the suit. Now, lordship, kindly see the, my
No,
lord,
where is the restraint regarding harvesting of paddy?
since we are restrained from, my lord, entering into the, my lord, land
The
in
person
question.
who is now having possession, he will harvest. If ultimately it is found that you were entitled to, he has to compensate for that.
Now, if, my lord, we are restrained, my lord, we went there to harvest the land, but the ultimately there is an injunction order. Police came and restrained us not to harvest the at position. Right, my lord, paddy is retained and it will be damaged, my lord.
No, why damage? Somebody who is having possession,
Yes.
he will harvest it.
Now, we are having possession, but we are restrained by the court not to enter into the suit land. To respect the, my lord, honorable court, we are not in a position to enter into the land. On the other hand, we are having, my lord, 25 numbers of residential houses. And interestingly, lordship, kindly see the suit.
No,
Lord-
you are only restrained, but the petitioner is not restrained.
But
Yes.
they did not cultivate it. We
But
cultivated.
they are claiming to have cultivated.
Yes. Now, lordship, kindly see there, my lord, funny part, lordship, kindly see at page 16. Page 16, my lord. Page 16, lordship will kindly see suit for
No,
deletion of.
Mr. Mandal, otherwise when the respondent has expired, unless he is substituted,
Yes.
we cannot pass any effective order.
That's what the situation is, that's, my lord, paddy is retained unless it is harvested, my lord, entire paddy would be damaged, my lord. That is why, my lord, we are restrained.
We'll allow the other side to harvest it.
My lord, since the other side has already died, my lord, sole respondent.
So what is your submission?
So, my lord, just, my lord, we are seeking permission, we may be allowed to harvest the, my lord, paddy, retained paddy, that must, my lord. In the maintain and then subsequently, my lord, we
No,
will.
there is no prohibition of harvesting.
In that case, my lord, that clarification may be, my lord, given, my lord, so that we can harvest.
The dispute is over the paddy or over the land.
Over the paddy as well as land.
So other side is claiming to have cultivated. They will harvest because it will not get damaged.
But since, my lord, they are not coming to harvest. because we are in
Heard
possession.
Mr. M.U. Mandal, learned counsel for the petition. Also heard Miss, what is her name? P. Adhikari, learned counsel for the respondent who submits that the sole respondent has expired on 9th of December 2025. Learned counsel for the petitioner submits that in view of the information received by the information given by the learned counsel for the respondent, he may have to take necessary instructions from the petitioner and take appropriate steps in this regard and prays for some time for the same. Prayer is allowed. Let this matter be listed on 7th of January. In between, you take instructions.
So, my lord, in between, my lord, if we are permitted to harvest the, my lord, land.
No,
Because the sole respondent already died, as my friend. reported.
his legal heirs will harvest.
That is not also. Now, my lord, interestingly, my lord, person from whom they executed the sale deed, my lord, they are not made party respondent.
No, these questions now we will not go into. And you first substitute the
Yes, that
7th of January.
7th of January. My lord, the paddy will be, my lord, damaged. Because they will never come because they are not in the position.
Let us see on 7th January.
Or, my lord, status quo as on today in respect of the possession. That will.
Then also paddy will get damaged.
of license.
Sorry, Lordship. Youngest council as will argue the cassette at two Lordship. Two Lordship.
Second half.
Item 11. May it please your lordship. My lord, this is the second appeal, your lordship, against the impugned judgment and decree passed by the learned appellate court below, my lord, in reversing the judgment and decree of the trial court, your lordship. Now, substantial question of law, my lord, we have formulated. It is at page 9, your lord. Now, here in this case, my lord, your lordship will find, my lord, from the pleading that there is a suit land, my lord, with DAG number, boundaries and all that. Now, the defendants, my lord, claiming a particular land, my lord, it is there also in the, my lord, schedule of their written statements. And both the lands are different. Now, peculiar aspects of the matter, my lord, the learned trial court at page 85, your lordship will find. Declared, my lord, right title and interest of the plaintiff on the basis of the Khatian exhibit 3, your lordship. Now, the, my lord, appellate court says that a Khatian was issued in the name of your father, plaintiff's father's name. So, plaintiff will not have any right title and interest over the suit land. And, my lord, the learned lower appellate court, my lord, declared, my lord, said that the defendants are having a better title on the basis of mutation certificate, your lord. Now, whether, my lord, the mutation order or mutation certificates can give right title and interest, your lord. No. 1996 Supreme Court, 1950, Calcutta High Court settled law, your lordship. Now, my lord, this is the thing, your lordship. And it is a case of, my lord, second appeal is a case of reversal, my lord. My lord, page 27, your lordship will find the appellate judgment, how the appellate court, your lordship, decided.
No, please read the substantial question of law in page 9.
By page 9, your lordship.
Please read it.
Whether the impugned judgment and decree 27/6/2025 passed by the learned appellate court below, ignoring the respective pleadings of the, my lord, pleadings in the suit and description of the suit land claimed by the plaintiff, appellant plaintiff, as described in schedule of the plaint filed with the seat with specific boundaries. I have a specific boundary, my lord. And the land claimed by the respondent's principal defendant as described in the schedule of the written statement filed in the suit with different boundaries than those of the suit land claimed by the appellant plaintiff, and thereby holding that the defendants have better title than the plaintiff in respect of the suit land. And on the basis of mutation certificate, Exhibit I, and the unregistered sale deeds, Exhibit B, Exhibit C, and Exhibit D, which do not relate to the suit land and are also inadmissible in evidence in accordance with the law. Unregistered sale deed, my lord, these are not admissible. And so also ignoring the law, there are two judgments of this honorable court, your lordship, that boundaries prevails, your lordship. And these are the two boundaries. Now, boundaries of the land claimed by the plaintiff and the boundaries of the land claimed by the defendant, these are different. The DAG number, patta number are also different, but to the appellate court, these are the same land. Land claimed by the defendant is the land claimed in the plaint, that is the findings of the learned lower appellate, my lord, court. And on that basis, my lord, suit of the plaintiff, my lord.
The trial court has decreed the suit.
Decreed the suit, yeah.
It was reversed by the appellate court.
It is reversed.
In whose possession the land is?
It is in my possession, my lord, and Khatian is there, that they had tried to evict me, and that's why, my lord, the plaintiff.
Is there any counterclaim?
No.
Yes, Mr. Gogoi, you are also there.
I am the former respondent in this matter, Lordship.
Okay, heard Mr. N. Dhar, learned counsel for the appellant. Also heard Mr. T. R. Gogoi,
Lords.
appearing for the pro forma respondent. Pro forma, and T. R. Gogoi, learned government advocate, appearing for pro forma respondent number 5, that is State of Assam. This appeal under section 100 of the Code of Civil Procedure 1908 has been preferred by the appellant, namely Shri Arjun Ravidas, impugning the judgment and decree dated 27/6/2025, passed by the Court of London, Civil Judge Senior Division number 1, in title appeal number 14/2020, whereby it allowed the appeal and set aside and reversed the judgment passed by the trial court, that is the Court of London, Munsif number 1 Kachar, on 18/12/2019 in title suit number 28/2007. After hearing learned counsel for the appellant, as well as considering the materials on records, following substantial question of law is formulated in the instant appeal dash within inverted comma, whether the judgment of the appellate court, appellate court is perverse in as much as it ignored the fact that the suit land and the land of the principal defendants are two separate plots of land covered by separate boundaries. Stop. Whether the judgment of the appellate court, impugned judgment of the appellate court, is also perverse in as much as the appellate court relied on the mutation certificate, that is Exhibit 1, and unregistered deed of sale deeds, Exhibit B, C, and Exhibit D, to come to a conclusion that the principal respondent has better title over the suit land than that of the present appellant. Issue notice. Since this appeal is admitted. Stop. Issue notice. Since Mr. T. R. Gogoi, learned government advocate, has already appeared for respondent number 5, no formal notice need to be issued to respondent number 5. As regards the other respondents, the appellant shall take steps for issuance of notice by speed post as well as by usual mode within 7 days, returnable after 4 weeks. Stop. Call for the records of title appeal number 14/2020 as well as title suit number 28/2007 from the respective courts. The registry shall take steps for requisition the record list accordingly.
My lord, we have a case case that may be disposed of, my lord, directing the parties to maintain status quo, your lordship, in respect of the suit, my lord, until disposal of the appeal, your lord. The suit is for, my lord, confirmation of, my lord, confirmation of possession, your lordship, confirmation of first position of the.
No, you don't have a case in this case. Because your suit was dismissed.
That's why, my lord, we may not have stay. We may not have stay. But, my lord, injunction, my lord, your lordship can give. That's why, my lord, we prayed for injunction, your lordship.
What injunction?
Injunction to maintain status quo, your lordship.
We
Otherwise,
will issue notice. Is there any averment that status quo would not be? Because that suit was your suit. It was dismissed.
It was dismissed by the appellate court.
Ultimately, it was
Yes, yes,
dismissed by the,
ultimately it was dismissed. So there will be no stay, my lord.
no
Because
stay.
stay will not serve any purpose. So, my lord, cardinal principles of the, my lord, civil suit, Supreme Court says, my lord, that is to maintain status quo during the pendency of the, my lord, suit or the appeal, your lordship.
No, we may issue
2005
notice.
104, your lordship.
Lordship, as did states, lordship, issue may be notice only, lordship.
We are issuing notice in injunction.
Lordship.
No,
2005, Supreme Court 104.
no, not without hearing the other side.
Without hearing the private respondent.
Yes.
Yes. Parties likhibho, issue notice. Let this matter be listed. We will give a fixed date. 30 January.
Lordship. Obliged, lordship.
Agatu 30 January.
I feel the lordship. Lordship, the present appellant is agreed by a judgment and decree dated 25/2025 passed by the learned civil judge Durhat, affirming the judgment and decree of the learned trial court. Lordship, the lordship will find a substantial question of law in page number 6 of my appeal memo. Lordship may kindly directly go to number D of my substantial question, D. Page number 6.
Yes.
May I read mine? What is the substantive question of law is that whether the trial court as well as the first appellate court have failed to appreciate the plea of adverse possession taken by the defendant in the written statement as well as the evidence regarding the period of coming into possession.
What was the suit for?
Right title, interest and delivery of first possession.
You were the plaintiff, defendant.
Defendant.
Then what happened?
Case of the plaintiff was that the property was belongs to his father initially. Out of 4 katha land, 2 katha, 4 acre land were gifted to the plaintiff. And that's the claim of the plaintiff is that we took possession in his property. Thereafter, he approached the court below.
And then
Our
recovery
case
of,
is that, our case is that in a
suit was for recovery of khas position.
Yes, khas position. And our plea was that we were in the suit property for last more than 50 years. It is mentioned in the written statement also, but that issue was never dealt with by the trial court. No issues framed on that in that regard.
Regarding adverse possession.
Yes, adverse possession. First of all, secondly, one more thing, Lordship. PW1 plaintiff himself admitted that the suit at that time of filing of the suit property was under mortgage of State Bank of India. It is correct. For a moment, we accepted that he is the owner of the property. The title is with him, a right and interest. That we took a plea for non-joinder of necessary party also. That is also not included.
Now, whether any execution case has been.
Yes, lordship. Execution case is initiated already. In my, I have categorically stated in para 3.
Any plea regarding adverse possession was taken in written statement.
Yes,
Issue was not framed.
yes, not fair.
In appellate court, whether you took that issue, plea. First appellate court.
Verbally, but it is, yes, appellate court, it is also not dealt with, lordship. But in written statement, page number 51, for a moment, if your lordship, para 7. Para 7 and para 10. Although lordship, the word adverse possession is not clearly mentioned, but lordship, your lordship go through the statement, averments, para 7. That issue was never dealt with and not framed by the learned trial court.
Did you adduce evidence
Regarding my
50 years?
issue was also not framed, my lord, and I am not sure. Actually, the suit was initially against my husband. After the divorce of my husband, I was impeded. Now the present defendant number 1. So my husband contested the case. Now,
Ah. This is item number.
12.
Heard Mr. P.P. Borthakur, learned counsel for the appellant. This appeal under section 100 of the Code of Civil Procedure 1908 has been filed by the appellants impugning the judgment and decree dated 25/2025 passed by the Court of Learned Civil Justice Senior Division Jorhat in title appeal number 2/2020, whereby the decree and judgment passed by the Court of Learned Munsif number 1 Jorhat in titles on 22/1/2020 in title suit number 49/2015 was affirmed and upheld. After considering the submissions made by learned counsel for the appellant and after going through the materials available on record, following substantial question of law is formulated in this appeal. Whether the first appellate court as well as the trial court committed perversity in ignoring the specific pleadings of the appellant in their written statement, wherein they took a specific plea of adversely possessing the suit land for 50 years by constructing their dwelling houses thereon. issue notice to the inverted commas close. Issue notice to the respondents. The appellant shall take steps for issuance of notice upon the respondents by speed post as well as by usual mode within a period of 7 days from the date of this order, returnable on date of the 5th of February. List accordingly. I to you. This interlocutory application has been filed. Councillor Nam Likhipo has been filed by the applicants under Order 41 Rule 5 of the Code of Civil Procedure in connection with regular second appeal number 215/2025, praying for stay of the execution of the impugned judgment and decree of the trial court as well as first appellate court. Learned, what is the execution case number?
But it's already under process.
Learned counsel for the applicant has submitted that the respondents have already filed an execution proceeding before the executing court. Stop. Issue notice to the respondents. The petitioners, the applicant shall take steps for issuance of notice upon the respondents by speed post as well as by usual mode. Stop. In the meanwhile, since the connected regular second appeal has been admitted for hearing and notices have been issued to the respondents in that case, the till next returnable date, the execution of the impugned judgment and decree shall remain stayed. List accordingly. Records call করেছেন in main case. Appeal is admitted. Call for the records of the trial court as well as first appellate court from the concerned courts. Registry to take steps for requisitioning the aforesaid records.
Order item 13.
Please allow. Much of the trial court records has been reviewed. The matter may be fixed for hearing.
The service is complete. 2005 matter.
Much earlier, this case was dismissed for default. Thereafter, it was restored. And after that, several appellant as well as respondent died.
Okay, heard Miss V. Rai, learned counsel for the appellants. None has appeared for respondents on call. The office note, you have gone through the office note?
The trial court has-
The office note dated 15/12/2025 shows that the records of the trial court as well as first appellate court have been received. And therefore, this case is ready for hearing. List this matter for hearing after four weeks on a date to be fixed by registry.
Deeply obliged.
14.
But this case, notices on respondent about 3 and 5 were not served because of insufficiency of address. So I may be permitted to take steps again. Some time may be granted.
Heard Mr. P. Khatunia. Who is for the other side? You are appearing? Heard Mr.
Yeah,
P. Khatunia, learned counsel for the appellant. None has appeared for respondent. Number respondent. It appears from the office note dated 10/12/2025 that the notices issued to respondent number 3 to 5,
3 and 5.
3 and 5 could not be served.
So they were not found insufficient address. That's 103 address not found. That's
Could
105.
not be served. Moreover, the notices issued to respondent number 4 has not yet returned. In view of the above,
And 5 also. 5 insufficient address.
yes, in view of above, the counsel for the appellant has prayed for some time for ascertaining the correct address of the respondent number 3 and 5, and then to take fresh steps on them. The prayer is allowed. The appellant is directed to take fresh steps for issuance of notice upon respondent number 3, 4, and 5 by speed post as well as by usual mode after ascertaining the correct address of respondent number 3 and 5. Stop. It also appears that the records of the trial court as well as our first appellate court has arrived. List this matter after 4 weeks.
Very pleased, Your Lordship. Lordship, in the office note, Lordship, regarding respondent number 10 and 11, a notice given in office note dated 9/12/25. But while giving this note, Lordship, the order passed in IA number 1656 of 24, that is 31/7/24, is not taken into account. Here, Lordship, this respondent number 10 and 11 are the pro forma respondents. They did not contest the event suit. I am the defendant in the suit. The pro forma defendant, they only filed, Lordship, a written statement against the counter claim. Apart from that, they have not appeared in any proceeding. Even the second appeal also, then, Lordship, we have filed
10 and 11.
10 and 11.
My lord, 10 and
Formal.
11 is not required, my lord.
Not
We
required.
can dispense
not
with
required.
under order 41, rule 14.
It's not required because Lordship kindly see order dated 31/7/24 in Miss Case 1656. 1656. Here, para 4 of that order, Lordship, it is categorically stated the notice were also duly served on opposite party number 10 and 11 who failed to appear in spite of due service of notice on them. That part of the order has not been reflected in this office note. Otherwise, the case is ready, Lordship, for hearing. Substantial question of law has already been framed. TCRO is also there. So it can be listed for final hearing. Except this, it is appellant and respondent number 1, other that doesn't have any stake in this matter. Government are made party because some land acquisition part was there, but decrease against me.
Number
1, my lord.
1, as well as Miss D. Burman appearing for 2, 3, 4, and 6. Any other counsel? Miss S. Sharma, learned counsel for respondent number 7. What is the name? And Mr. R. Boro, learned counsel for respondent number 5. On perusal of the office note dated 6/12/2025, it appears that what happened to respondent number 8 and 9?
8 and 9 already expired during the pendency of the suit. Then we have filed this miscase lordship. IA number 1653 from exempt to substitution.
Okay,
And the
then-
lordship is allowed. In this order itself, it is reflected in para 4 that service is complete in respect of respondent number 10 and 11.
Correct, madam.
Last line, last. It appears that the notices issued to respondent number 10 and 11 have returned with a postal endorsement within inverted comma not known. Learned counsel for the appellant submits that the respondent number 10 and 11 did not contested the suit apart from the fact that they filed written statement before
Against the counter, not in this.
written statement before the
Right.
trial court against the counterclaim only. And therefore, their presence notice to them may be waived in this appeal. Learned counsel for respondent number 1 also does not have any objection to the said pair.
Right.
Stop. Considering the submissions made by learned counsel for the appellant, the notice to respondent number 10 and 11 is waived in this appeal, as their presence may not be necessary for consideration of the instant appeal. Moreover, this appeal is also an all pending appeal of the year 2014. The records of the trial court as well as first appellate court have already been received. Stop. This case is accordingly, this appeal is accordingly ready for hearing. Raise this matter, yes. 29th January.
Right.
Raise this matter for hearing on 29th January.
Obliged.
Highly obliged.
19.
29 slot 2 মই দিলো যেতিয়া আপনি কেনেকে গম পাব 29 item number
19, my lord. May it please, Your Honor.
yes
My lord, by order of this noble court, my lord, we have take justice service, my lord. The
Yes.
respondent, my lord, refused to take, my lord, service of notice, my lord. And my lord, with that effect, my lord, we have also filed an affidavit,
thus is refused
my lord.
then we cannot hold it to be a due service.
My lord, order 5, my lord, rule 9, sub rule 5, my lord.
Order 5
Order 5, rule 9, sub rule 5, my lord.
read it.
When an acknowledgement or any other receipt purporting to be signed by the defendant or his agent is received by the court or postal article contains, this summons is received back by the court with an endorsement
That
purporting,
is applicable only when the notice is sent through post.
my lord.
Thus the service is provided in order 5 rule 9A. And in 9A, there is no such stipulation.
My lord, 9A, my lord, sub rule 4, my lord. If such summons when tendered is refused or if the person served refused to sign an acknowledgement or receipt of any reason, such summons cannot be served personally, the court shall on application of the party reissue such summons served by the summons.
So what it provides, it has to be reissued. You cannot take.
Hello, but we also take register post or my lord, usual process, my lord, and justice service also. my lord. He
But
refused.
register, if suppose registered post is refused, then we can take view that it is duly served. But if dusty service is refused because of the provision in the CPC, we have to direct fresh taking of fresh steps. You take fresh steps by speed post.
My lord.
Heard Mr. H.P. Gwala, learned counsel for the petitioner, who submits that the petitioner, in pursuant to the directions of this court, tried to serve the notices of this case on the sole respondent.
My lord.
Sole respondent. However, the respondent refused to accept the notice from him, and therefore prays for deeming the service to be duly deeming the notice to be duly served on the respondent. Stop. After consideration of submissions made by learned counsel for the petitioner, in view of the provision of Order 5, Rule 9A, capital A, within bracket 4, in an event of refusal of the acceptance of notice by the addressee, the court shall have to reissue the notice and summons. Accordingly, the petitioner is hereby directed to take fresh steps for issuance of notice upon the respondent by speed post within 7 days from the date of this order, returnable on 29th of January 2025. List accordingly.
Item 20.
Please, your lords.
Yes.
Lordship, we have filed the counter affidavit, Lordship, but it has not come on a record, Lordship. The same has shown in the website, but it's not in the record, Lordship. So kindly give some time so that
Your
we
Lord.
can file a fresh affidavit.
Counter affidavit has to be. We will direct the registry to place the counter affidavit tomorrow.
Please, your lords.
You,
Tomorrow.
you have,
Your lords, I have already argued they had the matter was adjourned because their counter was not uploaded. Last time also time was granted to them to ensure that the counter is online, is uploaded, your lords.
there is the IA.
Yes, your lords. This is the matter in which insolvency matter, your lords, in which liquidation is going on, your lords. Your lords. This was extensively argued on the last date by
Heard Mr. N. Goenka, learned counsel for the applicant appearing through video conferencing. Also heard Miss, what is her name? Ms. A. Sharma appearing on behalf of Mr. B. Chakravarti, Lanet's Central Government Standing Council, appearing for opposite party number 1, who submits that the Union of India has filed a counter affidavit against the application made by the present applicant. However, same is not on record and therefore prays for directing the registry to place the counter affidavit filed by the Union of India on record. The prayer is allowed. The registry to do so and list this matter again tomorrow.
Your Lordship,
18
can it be
at
taken up at higher up at board, Your Lordship, if request.
at 2 p.m.
Please, Lord.
At 2 p.m.
Highly oppressed.
May I please, Your Lordship? Lordship, may I pray this letter may become up after vacation, Your Lordship. My senior C. Bora has some difficulty today. He could not.
What is your name?
R. Bora, Lordship.
Who is for the other side?
Other side,
None has appeared.
yes.
Why it has come up for in
Today,
order?
sending to Your Lordship, my brief is not with me, Your Lordship.
But since on many last occasions, you are praying for adjournments only. Okay. Heard, Mr. What is the name?
R. Bora.
R.
Boro.
Boro, Learned Counsel for the petitioner who prays for an adjournment on the ground that the conducting counsel for the petitioner has some personal difficulty today. The prayer is allowed. Let this matter be listed, fixed date.
Immediately after
30th January,
30th,
30 January.
oblige, Your Lordship.
May it please, Your Lordship. Lordship, pleadings is completed, my lord. The matter may be fixed for admission hearing after vacation, my lord.
Okay. I have filed my affidavit in opposition. Matter may be listed immediately after.
When have you filed?
On 29th October.
Heard, Mr. What is your name?
M. Sharma.
M. Sharma, Learned Counsel for the petitioner. Also heard Mr. R. Ali, Learned Counsel for the respondent, sole respondent.
Lordship, sole respondent.
Since no, stop. This case is ready for admission hearing. Hence, let it be listed for admission hearing on 27 January.
In item 23, Lordship, respondent number 2 has expired during pendency of the appeal. And as per information received from my line of claim, that substitution has already been recorded in the original appellate court itself. But I could not ascertain because judgment, there is no reflection. So I have to implement the new legal layers of respondent number 2. And respondent number 23 has expired on November 2025. We have to file an application for substitution of legal layer of respondent number 23. And in respect of respondent number 2, we have to implement the person who has been already implemented as a respondent.
So you have to file an application. Heard Mr. S.K. Goswami, Learned Counsel for the appellant. Also heard Ms. P. Bhattacharya, appearing for
Respondent number 5, 6, 7.
Learned Counsel appearing for
Actually, notice on all the other respondents has been charged, Lordship. As per office note dated 1/11.
respondent number 5, 6,
7,
7, 8,
12, 14, 15,
12, 14, 15,
16, 17, 18,
16, 17, 18, and
22, 24, 25,
22, 24, 10, 25,
27, 28,
27, 28,
32,
32,
37, 38, 39,
37, 38, 39,
41.
and 41.
Lordship, as per office date dated 1/11/2025 as well as 12/12/2025, Lordship, LCR has been received and notice has already been served on all respondents. And 23 also served after
Yes.
submission notice is expired.
It appears that the notices
Already she has filed local law for 23 also, but 23 expired.
issued to all other respondents have been served, stop. And the records of trial court as well as first appellate court also, as well as first appellate court have been received. Learned counsel for the petitioner submits that the defendant number two.
Defendant number 2 has expired during pendency of the appeal. And he has been already been substituted. That has not been reflected in the appellate order. Though we have not included.
Defendant number 2 in the original title suit had expired during the pendency of the first appeal. And by the order dated 28 to
28 to 2025.
2025.
Substituted on 4/3/2025.
No, as per order dated 4/3/2025, the legal representative of deceased
Lady sub.
respondent number 2 were already allowed to be substituted by the first appellate court. However, learned counsel for the appellant submits that as the name of the legal heirs of the deceased respondent number 2 were not reflected in the first appellate court's order,
That's correct.
judgment of the first appellate court, he could not make them a party in the appellant could not make them as party in the instant regular second appeal. He therefore submits that the appellant may have to file an application under Order 1, Rule 10 of the CPC to implead legal heirs of original defendant number 2 in this appeal and seeks some time for same.
And 23 also expired.
Learned counsel for the appellant further submits that during the pendency of the instant regular second appeal, the respondent number 23 has also expired. And in that regard also the appellant shall have to take appropriate steps for substituting the legal representatives / heir of respondent number 23. And for the same, some time is prayed for. If prayer is allowed, let this matter be listed after 4 weeks.
After vacation.
After 4 weeks, the appellant may take appropriate steps as prayed for by him.
Only thing is, Lordship, I have discussed with the matter. There is a stay petition. The Honorable Court at the time of admission of the appeal has stated that stay petition will be considered after appearance of the response. So Lordship will consider on the next step.
Yes, let the respondent appear. Because
He
one
has already appeared, Lordship, for all the respondents.
one respondent has expired.
But she has already filed local number for the person who has died.
Okay, we'll go. This is RSA. Substantial question of law has been formulated.
Lordship.
Okay.
Appeal is already admitted.
Oh.
And Lordship, as far we have seen the record of the trial court where execution has fixed on 6th of January.
But record is here, Lordship. All the records has come, Lordship. Here.
No, execution case record was not.
Trial court
6th of January.
So what should we do?
Lordship, till next date, Lordship, execution should not be stayed because I have to subsidy. Otherwise, on 6th of January, it has been fixed.
Any submission?
because that is already admitted, Lordship.
Learned counsel for the petitioner has submitted that the decree holders have already filed an execution case before the executing court and the next date is fixed on 6th of January 2026. He prays for staying the execution till next returnable date. No, till the next date of this appeal. The prayer is not objected to by the prayer is allowed. Prayer is allowed. The execution of the impugned judgment and order
Title execution case number 26 of
in
94.
title execution case number 26
of
1994 94 shall remain stayed till next returnable date.
May it please, my lord. My lord, we are before your lordship under Article 227, sealing the order of the learned civil judge senior division Karimganj, whereby compensation has been allowed to the respondent number 1. My lord, the issue here is that as per section 16 subsection 3 of the Indian Telegraph Act, only the learned district judge is empowered to hear this matter. So this order suffers from lack of patent jurisdiction, my lord. There's no jurisdiction of the learned civil judge senior division to entertain the matter, my lord.
My lord, I am
Whether
appearing for
appearance is complete.
respondent number 1 and 2, my lord.
How many respondents are
There
there?
are, my lord, 7 respondents.
As regards
Four-
other
4 to 7, they already.
4 to 7, Lordship, I am.
Respondent number 3 is there.
respondent number 3. Who is respondent number 3?
Northeastern Transmission Company, substation at Badarpur Ghat.
You have to take fresh steps on
It has
respond.
In the office note, my lord, it has been shown to be duly served.
Where? Which of it?
Office note dated 13/11/2025.
Okay, okay. Then we'll fix this matter for admission hearing.
My lord.
TCR also, my lord, required. TCR is not called.
No, they are questioning the jurisdiction.
itself.
For that, records may not be necessary. We can decide the question of jurisdiction because the impugned order is before us. Heard Mr. R. Sharma, learned senior counsel, assisted by Miss
And Khera.
Mr. N. Khera. Where is Mr. N. Khera?
Just getting to answer.
He is not assisting you.
My lord.
What is your name? Miss P. Fukan, learned counsel for the petitioner. Also Mr. T. R. Gogoi, learned government advocate, appearing for respondent number 4 to 7, as well as Mr. K. Uddin, appearing for respondent number
1, 2.
1 and 2. On perusal of the office note dated 13/11/2025, it appears that the notices issued to respondent number 3 by usual process have been duly served. Stop. Hence, the notices issued to him to respondent number 3 is held to be duly served. Stop. Since the service of notice on all the respondents is complete, this matter is ready for admission hearing. Hence, let this matter be listed for admission on 27 January.
Can it be
The
on 30th January?
30th January. On 30th January.
Interim orders.
The interim order granted earlier shall continue till next date.
Well.
List accordingly.
Obliged.
6.
My pleasure. As per office note dated 23/10/2025, notice received by employee of Messrs. Ma Timbers. Not by the respondent.
You have taken by registered post.
Gotcha.
When?
Immediately after first order, Lordship.
Now what is to be done?
Lordship, I will take fresh step through Dusty as well as through the council who appeared before learned trial court. I may be allowed, Lordship.
By speed post also you take so that we can go through the postal track consignment report.
What happened in this matter by impugned order, Lordship? Someone was issued to the marriage officer. Whereas case is for partition between daughter-in-law. Kindly period for a moment, Lordship. Urgently, interim order is required, Lordship. Otherwise,
Where is the impugned order?
interim order, Lordship will find that page 115. Thereby, 4 applications filed by the plaintiff to the suit, Lordship, was allowed. If your Lordship kindly peruse for a moment, what is the suit for? Suit for partition, and another suit is pending challenging the marriage status, marital status of the plaintiff. In both the suits, Lordship, different issues were framed, but the learned civil judge, senior division number 2, in a case of partition, call for marriage officer from sub-register, Lordship. Whereas that issue is pending in different suit, Lordship.
Before which court? Some other court?
Some Munsif number 2, civil judge junior division number 3, Lordship, sorry, 3. If your Lordship kindly peruse for a moment Annexure 1. I will take only 5 minutes time, Lordship. Annexure 1. Suit filed by,
On what grounds the prayer was allowed?
if your Lordship kindly peruse what issues were framed in both the cases. After perusal of prayer of both the suits, Lordship.
No, you first take steps. Because how it will cause harm to you. Suppose they come.
After allowing that application, Lordship, on last date, marriage officer was come to civil court, Lordship,
Yes.
for production of marital records, whereas that issue is pending in another suit. So definitely, that amount to cause serious harm. In a suit of partition, the marriage status cannot decide when another suit, specially challenging the marriage, is pending.
Whether any issue has been framed
Yes, Lordship. That I am going
regarding
to say,
marriage.
Yes, Lordship.
In this case.
Not in this case, in different case, where I have challenged marital status.
So why the marriage officer was summoned?
That is my point here. That is the ground in this revision application. So beyond the issue, Lordship, I have mentioned all issues, Lordship will find at.
No,
page
you
number
point
4.
out to the court that his examination is not necessary.
I filed my written statement, written objection.
So-
Stating all these things. In fact, I have also brought.
What
all
was the reasoning given by the trial court in the impugned judgment, impugned order?
So we'll find that
On what grounds the prayer was allowed?
page number 125. Last paragraph. Against petition number 2968 and 2969.
You are claiming partition on the basis of your marital relationship with the,
Yes, that suit is pending.
therefore court felt it necessary.
No, Lordship, when issue is framed in another suit, specific issues are there.
No, but it will not cause any harm to you.
Otherwise, the suit pending before learned Munsif, that will become
We-
infructuous.
No, we will decide after appearance of the other side.
Case is
It is not a case of urgency. When is the next date fix?
21 January, 21st January,
We'll fix this before that date.
19 January. Lordship.
Okay.
In the meantime,
Heard Mr. R. Ali, learned counsel for the petitioner. On perusal of the office note dated 23/10/2025, it appears that the notice is issued to sole respondent.
so that-
Sole respondent could not be served through usual process. learned counsel for the petitioner submits that the petitioner may be allowed to take steps by way of dusty mode or issuance of notice upon sale respondent. The prayer is allowed. The petitioner shall take steps for issuance of notice upon the respondent by speed post within 7 days from the date of this order, returnable on 19th of January. The petitioner is also allowed to take steps for issuance of notice upon the respondent by way of dusty mode. Stop. In the event the petitioner is able to serve the notice through dusty mode, he shall file an affidavit of compliance to that effect before this court on the next date fixed, list accordingly.
27 and 28 is connected, Lordship, review. Here, Lordship, State of Assam has also filed review application that is not numbered.
That has not been listed.
Not numbered, therefore not listed. So
Both
the-
both should
Yes, sir.
on different grounds.
on different ground.
In fact, my lord, possibly there are 4 areas where they prayed for enhancement. Reference court rejected, then they came before your lordship, and your lordship also rejected. Out of 4, 3 rejected. 1 was allowed. Against that, we have filed a review, and they have filed a review in respect of the remaining 3.
Okay. Then
Ultimately,
then it should come
together.
together.
Right.
Come together in the first week of January, Lordship.
First week of January, we have no dates.
Then immediately after reopen.
Yes, after Bihu vacation, we will give a fixed date. Heard Mr. S. Datta.
Deka.
Sorry, S. Deka, learned counsel for the petitioner. Also heard Mr. D. Majumdar, learned senior counsel, learned additional advocate general, assisted by Miss D. D. Burman, learned government advocate, appearing for respondent number
1 and
1 and 3. Also heard Mr. M. Nath, learned senior counsel, assisted by Mr. A. Bhattacharya, appearing for respondent number 2. This application under order 47 under section 114 read with order 47 rule 1 of the Code of Civil Procedure has been filed by the petitioner praying for review of the judgment and order dated 1/11/2025 passed by this court in LA Appeal number 2/2019. Learned additional Advocate General has submitted that the state of Assam has also filed a review application which is yet to be listed, and prays that both the matter relates to the same judgment, they may be taken up together. How we will direct the registry if
My
it
lord,
is?
lordship simply say that let this matter be listed along with that, because there is a possibility that our review may be listed this Friday, so it will come together.
Let this matter be listed along with the review application filed by the state of Assam.
That will suffice.
Let this matter be listed on the state of Assam on
The date, lordship may indicate this Friday also, there is a likelihood that the review filed by us. We file it on 25th of 11/2025.
Friday, it will be difficult.
No, but I'm saying that if it is already there in the pipeline and it's going to be listed, in that event, lordship may not indicate any date, let it come together, that much will do, mine. whenever it is listed.
Date may be fixed and the registry will look after it.
Whenever it is listed, both will be listed together. That much will somehow.
You don't want a fixed date.
Only the
I
date may be
don't,
fixed also.
I don't say that, my lord. What I'm saying is Friday, if this matter is going to be listed, then by virtue of this order, again, it will not be listed.
Okay, okay.
If listed,
We will, thereafter we'll fix it.
My lord,
if
Both.
not listed, then again it will be delayed.
lordship may simply say that let it.
Okay, this matter may be fixed on the fixed date. If that this come in Friday, then that date.
We can fix that on that.
Yes.
List this matter on date at the due. 20, no, after 26 January. 6 February,
Too long and the January, that's the last part.
last week of January,
No, no, last week of January, I have some difficulty.
6th of February, 6th of February.
Public.
Item 29. Not, it's a early appeal, my lord. So it is part by time. I'm appearing on behalf of RDB CDC, S1 number 2 here. She has got some personal difficulty today, so she could not come. And lordship, moreover, in the delay petition, an affidavit needs to be filed, lordship. So lordship, matter
There is a delay.
of 707 days. So lordship, affidavit is required to give
You will be filing objection.
objection.
Okay, we'll reflect that in IA लिखिए. Heard me. This is item number
29. 29.
Your name is not there, Mr. Rashid.
Not M.A. Sheikh.
May. Oh, yes, it is.
Yes.
Heard Mr. M.A. Sheikh, learned counsel for the applicant. Also heard Mr.
A.R. Tohbildar
A.R. Tabildar,
on behalf of R. Devi CDC.
appearing on behalf of Ms. R. Devi, Learned Central Government Council for respondent number 2, who submits that the Union of India would be filing. Union of India is a party.
Two lordship. Union of, yes, general manager.
The Union of India would be filing. Who is representing?
General manager, NFL.
Mr. Burman, Ms. Burman, you are for what? Also heard Ms. D.D. Burman, Learned Senior Government Counsel, appearing for respondent number 1. Learned Counsel for respondent number 2 has prayed for some time for allowing the respondent number 2 to file a written objection against the prayer for condonation of delay filed by the present applicant. The prayer is allowed. Let this matter be listed.
After vacation.
Date of review. 30 January. Yeah.
In this case, lordship, the respondent number 1 filed a suit, that is annexure 1 page 14 is the plaint.
Yes.
In this case, what happened, lordship, I got an abandon number, and on the basis of abandon number, I am possessing a portion of land, lordship.
What? Avantan Nama.
Yes, like allotment.
Okay.
So
Who allotted?
government, lordship.
Okay.
That was challenged by the respondent by filing this title suit, lordship. The
Thereafter,
prayer portion I am reading,
page number.
23, lordship. His case is that this is a walk-up property. Already there is a letter from the CEO of walk-up tribunal that walk-up lordship that the plot of land was already made walk-up. The page 23 is his prayer portion.
Yes.
a decree declaring the right title and interest of the Rahmania Koborstan, that is the plaintiff number 1 over the Schedule A land, including the Schedule B land appended to the plaint, and decree for recovery of cash possession of the Schedule B land by evicting the defendants, their men, agents, assigns, attorneys, and materials from the Schedule B land. And a decree declaring that the Abonton Nama dated 29/6/1994 white book number so-and-so of year so-and-so under the government of MNP scheme is null and void ab initio, illegal, contrary to law, and not binding upon the plaintiffs. Before institution of this suit, Lordship, the plaintiff filed a suit before the Munsip Court, Dhubri, that was returned to file before the Waqf Tribunal, as his case is that this property is a Waqf property. So after coming to Waqf Tribunal, he withdrawn the suit with liberty to file again. Thereafter, this title suit was filed. And this suit, while this suit was going on, my patta was cancelled. On the basis of Abonton Nama, patta was issued in the name of the petitioner. That was cancelled. So I have
Cancelled
by government.
under some court direction or
No, Lordship. no.
otherwise also?
Otherwise.
Okay.
On the, in fact, Lordship, on the objection of this plaintiff. Thereafter, Lordship, I filed a suit that my patta was illegally cancelled. That suit, they raised an objection that this is a work of property, civil court has no jurisdiction. Thereafter, I filed an misappeal challenging that order of the trial court. The misappellate court held that, I'm reading that order, Lordship. Page 64.
64 is the order
Passed in the misappeal
misappeal by the
by the appellate court, Lordship, Lordship, Civil Judge Senior Division, Dhubri. Page 58 is the first page, misappeal number 03 of 2020.
this is against the first case,
Against the case.
first time
The second title suit, Lordship.
before Waqf Tribunal.
Before civil court. This present petitioner filed.
You filed.
I have filed, Lordship. When my patta was cancelled, then I have filed the suit, Lordship.
Okay.
So my suit was, they raised an objection, then this is an Waqf property. So the civil court has no jurisdiction. The Munsip court directed to file it before the Waqf Tribunal. I have.
Your suit also.
Yes, Lordship.
Okay.
So I have filed misappeal, challenging that order.
Okay.
They have not challenged, they have filed their suit before the Waqf Tribunal. I have challenged that order, and misappellate court held that in page 64. Paragraph 13.
Yes.
However, the bare perusal of the relevant order of the Waqf board marked as Annexure 1, it appears that the suit land has been registered as Waqf property merely on the basis of an application and khasra, which is a disputed document, without proper inquiry and without following the due procedure as laid down under Chapter 5 of Waqf Act in the letter and spirit. Moreover, we see the materials available in the case record. We will find that the claim of the appellant over the suit property is on the basis of Abonton Nama issued in the year 1994, that is prior to the creation of the Waqf Act. Not to speak of aforesaid order passed by CEO in the year 2013. So after this finding, Lordship, my suit was remanded. Relevant portion, page 65. Hence, under the above facts and circumstances, I am of the considered opinion that the observation made by the learned Munsip number 1 Dhubri was not justified in law and facts. Accordingly, the order dated 19/12/19 passed by the learned Munsip Dhubri is hereby set aside. And in consequence, the appeal is allowed on contest with cost. Send back the case record of Midje case number 96 of 2019 to the court of the learned Munsip number 1 Dhubri with a copy of the judgment. So after this order, Lordship, the suit is pending before the learned trial court. They are also contesting, Lordship.
Which court?
Before the Munsip court, Lordship. Munsip number 1.
The suit filed by you.
Yes, Lordship. My suit, which was filed by me, Lordship.
Okay.
That was, they have not challenged this order. Then, Lordship, after before the Waqf Tribunal, I raised a point that an issue may be framed, additional issue, whether this suit will continue in furtherance of this order, as my suit is already continuing before the Munsip number 1. Thereafter, Lordship, they filed one CRP before this High Court, challenging this Appellate Court's order with limitation. Limitation was allowed, thereafter in CRP, notice was issued. But no stay order was.
CRP number?
CRP 65/2025. I have annexed the order, Lordship, Annexure 9, page 51.
Page?
81. Page 83 is the order dated 23/7/2025.
Okay, now what?
Only notice issue, no stay was granted. So my suit is still going on before the learned Munsip number 1 Dhubri. When I filed this petition before the Waqf Tribunal, that is page 66, Annexure 7, Lordship. I have filed one application under Order 14, Rule 5, read with Section 151 of CPC for framing of an additional issue, 66 page, and decide the same as a preliminary issue as per provision of Order 14, Rule 2 of CPC before deciding the other issues already framed by this Honorable Tribunal. By that time, Waqf Tribunal proceeded to the extent of cross-examination of DW1. At that relevant point of time, this petition was filed. They raised objection. Their objection also I have enclosed page 72
Against your petition.
against my petition.
Thereafter,
Thereafter, the Waqf Tribunal passed an order that is impugned in this case, Annexure 10, page 85. 86 is the relevant portion. In petition number 46425 under order so-and-so, filed by the learned counsel for the defendant praying for framing of an additional issue and that to be decided as per preliminary issue as per provision of Order 14, Rule 2 CPC before deciding the other issues already framed by this Honorable Tribunal. Also seeing the objection filed by the plaintiff against the petition number so-and-so dated so-and-so, heard both sides on the point of framing preliminary issues, I have perused previous orders and gone through the materials available on record. On perusal, it has come to light that issues in this case has already been framed and the case has reached to a crucial stage where the cross-examination of DW1 has been partly recorded and further cross has been reserved. That apart, what prima facie appears is that the preliminary issue involves disputed facts that requires evidence. It cannot be decided separately as a preliminary issue. It would not be just fair on the part of the court to decide a mixed question of law and fact as a preliminary issue if the facts are not clear from the plaint alone. Therefore, considering the above circumstances, this court is of the considered opinion that deciding the fate of the case by framing a preliminary issue would not result in fair and proper adjudication of this case, and accordingly petition so-and-so is rejected. Against this lordship, this civil revision has been filed. My limited prayer before your lordship, at this stage notice may be issued. Until their appearance, the further proceeding of the Waqf case may kindly be remained stayed, lordship. Otherwise, let's say on the same subject matter, civil court will give a decision and Waqf Tribunal will also give a decision. When already the Appellate Court held that the Waqf, this is not a Waqf property, not registered in accordance with the Waqf Act.
no, the civil court said that in detailed inquiry under section 5 of the Waqf Act
Lordship,
has to be
first, it
conducted.
has to be surveyed and then it has to be recorded in the registered, widely circulating in the locality, and thereafter it can be registered.
Ms. R. Chaudhary, learned counsel for the petitioner. This application under Article 227 of the Constitution of India, read with section 151 of the Code of Civil Procedure, 1908, has been preferred by the petitioner Mohammed Sabu Sheikh alias Sabur Ali, impugning the order dated 30-10-2025 passed by the Waqf Tribunal, Kamrup Metro, Guwahati, in title suit number 1/2021, whereby the prayer of the present petitioner to frame a preliminary issue under Order 14, Rule 5 of the Code of Civil Procedure. And further prayer to decide the said issue in terms of Order 14, Rule 2 of the CPC was rejected. Learned counsel for the petitioner has submitted that the title suit number 1/2021 has been filed by the present respondents before the Waqf Tribunal in respect of the property mentioned in the schedule, which schedule?
Yes, Lordship, that
Where is the suit? Plain
page 25.
property mentioned in schedule A.
B is a part of A schedule land.
As
where
well
B
as
is recovered.
schedule B of the plain. Stop. One of the relief sought for by the respondent in the aforesaid plain is recovery of khas possession of Schedule B land over which the respondents are having possession. Learned counsel for the petitioner submits that the Schedule B land was allotted to the respondents by virtue of a
Abonton Nama, Lordship.
Abonton Nama by the government in the year 1994. However, later on, the government cancelled the said cancelled the Abonton Nama.
Yes, Lord, Patta, Lordship. On the
Okay.
basis of Abonton Nama, Patta was issued, Lordship.
Later on, the government had cancelled the Patta and stopped. The present petitioners agreed with the cancellation of Patta in respect of Schedule B land.
Yes, Lordship.
In respect of Schedule B land had preferred a title suit before the court of learned.
Munship number 1, Lordship, Dhubri.
Which is title suit number?
Title suit number, Lordship. '52 of 2019, page 59, Lordship, in the separate court judgment.
Title suit number 52 of
2019.
2019. What has happened to that case?
Miss Appellate Court remanded the case to be decided by the first Munsif and still pending, Lordship.
Appeal was against what?
Appeal was against the order passed by the Munsif Court. I'm reading from the page 59, Lordship. This appeal under Order 43, Rule 1A of the CPC has been preferred by the appellant against the order dated 19/12/19, passed in Mid-J case number 96 by the learned Munsif number 1, Dhubri. So, Lordship, on 19/1/19, there is an order passed, page 43. Page 45 is the relevant portion, last two paragraphs. Now the question arises whether the suit is hit by Order 7, Rule 11D of CPC. The answer, in my opinion, is in negative, as Order 7, Rule 11D of CPC requires that in order to reject a suit on the ground that it is barred by law, the suit must appear to be barred by any law from the bare perusal of the plaint alone and not other materials seduced by the defendant.
Okay.
The finding that the suit is barred.
Key আছে last line. In the, before the court of learned Munsif number 1, Dhubri. In the said suit, the respondent had raised the question of
They raised an objection that civil court has no jurisdiction.
question of jurisdiction of the civil court to entertain the suit, as it was claimed that the suit property is a Waqf property. Accordingly, by order dated 19/12/2019, passed in Miss J case number 96/2019, the trial court returned the plaint to the present petitioner for filing the same before the Waqf tribunal. Being aggrieved with the aforesaid order of the trial court, the petitioners preferred a misappeal
03/2020.
before the court of learned civil judge,
Senior Division.
senior division, Dhubri. Stops. Said misappeal was registered in as misappeal number 03/2020. Stop. Learned counsel for the petitioner submits that by order dated by judgment, what is the date?
Date, Lordship, that is
Judgment.
9/5/2023.
Judgment and order dated 9/5/2023. The trial court, the first appellate court had set aside the order dated 19/12/2019, passed by the trial court in Miss J case number 96/2019, and allowed the appeal.
So there was no specific direction for remand, Lordship, but thereafter the plaint was.
Allowed the appeal. The learned counsel for the petitioner submits that thereafter the plaint was again presented. And the suit is presently pending.
For the Munsif.
Thereafter, the suit is presently pending before the court of learned Munsif number 1, Dhubri. Learned counsel for the petitioner further submits that the respondents had preferred an civil revision petition against the order of the first appellate court, which is registered as CRP number 65/2025, in which though notices have been issued to the opposite parties, however, no stay has been granted in
State the title suit of 52 of the
title suit number 52 of
2019.
2019.
As
And
per
I-
lordship, the next date is 6/1/2022.
And as such, the said suit is still proceeding. Learned counsel for the petitioner submits that in view of the aforesaid development, since in respect of the said suit property, the two cases are pending before two different courts, one before the Court of Learned Munsif number 1, Dhubri, that is title suit number 52/2019. 52 of 2019,
Yes, lordship.
and
52
and another before the Waqf Tribunal, that is title suit number 1
2021.
of 2025.
21.
Under such circumstances, the petitioner had filed an application before the Waqf Tribunal for framing a preliminary issue. Where is your petition?
At page 66. lordship.
Framing a preliminary issue as hereunder, within inverted comma, whether this honorable tribunal has got jurisdiction to try the instant suit in view of the order dated 9/5/2023, passed in Miss Appeal number 3/2020 by the Honorable Civil Judge Dhubri, inverted comma close. Learned counsel for the petitioner has submitted that since both the suits, namely title suit number 1/2021 and title suit number 52/2019 pertains to same plot of land. Continuation of the present suit, that is title suit number 2021, which was filed after the suit filed by the present petitioner, may result in conflicting opinion, and therefore the preliminary issue suggested by the petitioner is required to be framed and decided by the Waqf Board before further proceeding with the title suit number 1/2021. Stop. Issue notice to the respondents. The petitioner shall take steps for issuing notice upon the respondents by speed post as well as by usual mode within 7 days from the date of this order, returnable after 4 weeks. Stop. In the you have interim prayer?
Yes, lordship, page 12.
In the meanwhile, considering the submissions made by learned counsel for the petitioner as discussed in foregoing paragraph, as well as considering the fact that continuation of two separate suit in two forums in respect of the same plot of land may result in conflicting judgments by two courts, comma, the further proceeding of title suit number 1/2021 is hereby stayed. One of 2021 pending before the Waqf Tribunal, Kamrup Metro, Guwahati, is hereby stayed till next returnable date. List accordingly. Date at the 4 weeks of this. Release this matter on 5th of February. None has appeared for the petitioner on call. Release this matter after a week on a date to be fixed by registry.
In this matter, they have filed two regular second appeal challenging the allowing of the counterclaim and dismissal of suit, lordship. This regular second appeal is against the dismissal of the suit. And allowing the counterclaim, Monday, your lordship has condoned the delay and registry is directed to list the regular second appeal. So may I pray, lordship, both the regular second appeals may be taken up together?
Both relates to the same suit.
Same judgment, only one judgment. By the same judgment, their suit was dismissed, my counterclaim was declared.
Okay.
And I'm in caveator, lordship, so can it be on tomorrow or day after tomorrow, any day?
You have any interim relief?
They have urgency, lordship.
What urgency?
Started, my lord. On 19th, my lord,
Where is the other case? RSN.
RSF
Number, but IA was there on Monday. Lordship, IA civil number 4035 of 2025 for condonation in preparing.
Let both the Friday given cases.
Tomorrow, so your lordship. It will be listed in the supplement. Tomorrow if possible, lordship.
No, but tomorrow the order will not go to registry. Because I will sign the orders after getting down. So registry has to be directed.
Lordship, in this matter, I will object only because, lordship, at the admission stage, if it can be decided, lordship. So I have filed one caveat. So
Day after tomorrow we'll fix it. Yeah. Heard Miss S. Roy, learned counsel for the appellant. Also heard Miss R. Chaudhary, learned counsel for respondent / caveator, who submits that the appellant has filed another regular second appeal.
filing number, lordship, 14346 of 2025.
With filing number
346.
14346/2025. She submits that in the said regular second appeal, there was a delay which has already been condoned by this court, and registry has been directed to register this
Yes.
said appeal.
This is today itself.
Stop. She submits that as both the regular second appeal arise out of the common judgment passed by the first appellate court, it would be appropriate if both this regular second appeal are taken up together. He therefore prays for listing this matter tomorrow or the day after tomorrow. Learned counsel for the appellant does not oppose the prayer. Let this matter be, let this regular second appeal be listed along with the other regular second appeal filed by the present appellant within bracket filing number to same Agandi on 19th of December.
Direction to register the regular second appeal to the registry. So they will automatically register it, Lordship.
Item 25.
Obliged, Lordship.
None has appeared. Why this IA?
For modification of the bail order,
What modification?
the terms and conditions of the bail order regarding the amount and also the surety, government servant surety.
None has appeared for the petitioner on call. Mr. B. Sharma, learned counsel for the learned additional public prosecutor is present. List this matter again on 19 December.
Your Lordship, this application is filed for modification of the order, Your Lordship, for extension of time. Actually, in this case, what happened, Your Lordship? On 22, direction was given to appear on 25, Your Lordship. So certified copy was not issued on time. So therefore, we filed an extension petition that was modified. And that was modified on 26/9, Your Lordship. And the next day it was holiday, Your Lordship. So we issued the certified copy on 7/9, 7/10, Your Lordship. And the certified copy was couriered to the petitioner, but that was not reached in time, Your Lordship. In the meantime, they could not appear on time, so therefore NBW issued in this case. So fresh cause of action arises due to that, Your Lordship.
When you were directed to first appear?
25, Your Lordship, first.
25/9.
25/9, Your Lordship. That was on fixed date actually. Therefore, we filed an,
By order dated 25/9, 26/9,
yes, Your Lordship.
you were directed to appear.
Given a Lordship, extended time, Your Lordship.
Why you failed to appear?
Your Lordship, and it was, holiday, Your Lordship. And the order was given in the next, in the chamber, Your Lordship. Late hours, Your Lordship. So next day of holiday, on 7, we received the certificate copy, Your Lordship. After on 7 and 7, we received, and we, and page number 14, Your Lordship, we couriered it on 7/10, Your Lordship. Due to road blockage, could not reach there in time, Your Lordship. So it could not appear. In the meantime, MNW issued on 19, Your Lordship. So before that, we filed this petition.
Now, which order you
Your
are
Lordship,
paying?
fresh cause of action arises, MNW issued in this case. So we have to file a fresh petition on
Fresh petition.
yes, Your Lordship. It has become ineffectual. So
Now, what is your prayer?
Your Lordship, I want to withdraw with liberty, file a fresh, Your Lordship.
This interlocutor application you want to withdraw? Heard Mr.
That's right, Your Lordship.
S. Royal Learned Counsel for the petitioner, also heard Mr. B. Sharma Learned Additional Public Prosecutor. Learned Counsel for the petitioner has submitted that though the instant interlocutory application was filed by the petitioner for modification of the order dated 22/9/2025 passed in criminal petition number 1195/2025 by this court, as the petitioner had failed to appear before the trial court in pursuant to the directions of this court due to delay in receipt of the certified copies of the said order. However, in the meanwhile, the trial court has again issued a fresh non-bailable warrant of arrest, and the petitioner is intending to challenge that non-bailable warrant of arrest by filing a fresh criminal petition. Hence, he does not want to pursue this instant interlocutory application. Stop. The prayer is, and therefore he has prayed for allowing him to withdraw this interlocutory application. The prayer is allowed. The instant interlocutory application is dismissed on withdrawal.
File a fresh lordship, liberty lordship.
Liberty is always there because that is a fresh cause of action. You need not seek liberty. It is always there.
Okay, please, Your Lordship. This is an application under Order 22 for substituting the name of the petitioner by his legal heirs.
Petitioner died.
He died on 29 September, or 29 August 2025.
It is within the period of limitation.
Yes, Lordship.
Any objection? Heard, Miss, what is your name?
D. Devi.
D. Devi, learned counsel for the applicant. Also heard Miss
R. Shaha.
R. Saha, appearing for the respondent. For whom you are appearing? All respondents. All respondents. This application under Order 22, Rule 2 of the Code of Civil Procedure has been filed by the legal heirs of the deceased petitioner, praying for substituting their names in place of the deceased petitioner. Stop. Learned counsel for the petitioner has submitted that the petitioner, namely, what was his name?
Shmalu.
Suresh Malu, had expired on 29/8/2025, leaving behind the present applicants as his legal representative. She therefore submits that she further submits that the instant application for substituting the legal representative of the deceased petitioner has been made within the prescribed period of limitation. Hence, she prays that the application may be allowed. Stop. Learned counsel for the respondent does not have any objection against the prayer made by the applicants. In view of the submissions made by the learned counsel for the petitioners, as well as averments made in the instant interlocutory application, the prayer for substitution is allowed. The names of Srimati Ganga Devi Malu, Srimati Sashi Malu, Srimati Shruti Sirohia, and Srimati Surabhi Kabra be substituted in the cause title of the present, in the cause title of the connected CRP number 444/2019 as petitioner number 1 within bracket 1, 1 within bracket 2, 1 within bracket 3, and 1 within bracket 4. The petitioner shall submit a amended cause title showing the name of substituted petitioners as indicated herein above, within before the next date fixed, the registry is directed to list the connected civil revision petition again. কত letter date দিও? 6th of February. This interlocutory application is accordingly disposed of.
May please, Your Lordship. Because this interlocutory application has been filed for withdrawal of the part of the award amount that has been deposited.
There are objections. Mr. What is your name?
S. Vishwakarma, my lords.
S. Vishwakarma, learned counsel for the
Claimant. Applicant.
applicant / claimants. Also, Mr.
Behalf of KK
S. Sharma, appearing on behalf of Mr. K.K. Bhatta, learned counsel for the opposite party insurance company. This application, this interlocutory application has been filed by the applicant Dipali Hajorika Bora. How many claimants are there?
Only one claimant.
Dipali Hajorika Bora, who is the respondent number 1/claimant in connected MAC appeal number 288/2022. Stop. In this application, the applicant has prayed for releasing the 20% of the compensation awarded to her by the Motor Accident Claims Tribunal, and which has been deposited by the insurance company before the registry of this court in pursuant to the order dated 1/6/2022, passed in IA civil number 1555/2022. Stop. The counsel for the insurance company does not have any objection to the said prayer. Hence, the prayer is allowed. This interlocutory application is accordingly disposed of with a direction to the registry to disburse the 20% of the awarded amount deposited by awarded compensation amount deposited by the insurance company before it to the present petitioner / claimant after proper verification. This interlocutory application is accordingly disposed of.
Okay, in this case, though I am the appellant, he has filed an application seeking early hearing.
You have any objection?
Lordship, though an objection by the counsel who had engaged me as copy has been served to him also and me.
There
but
cannot
I
be
could
any
not- it is
objection.
Not on record. The only objection which from this record, if your Lordship kindly take up their application which they have filed. The application which they have filed, your Lordship, is on the basis of two notices issued by the PNB, Punjab National Bank, under section 13(2) and 13(4) of the SARFAESI Act. Now, my only thing is, your Lordship, I leave your Lordship to decide, but the fact remains, these two orders are appealable orders before the DRT, your Lordship. Because 13(4) steps, though a notice, my learned colleague will obviously point out to that. Notice under 13(4) has been issued to them on 15/10/25, annexure 2, at page 11, I think it will be page 11. Now, this particular notice, which has been admittedly issued under 13(4), is an appealable order under section 17 of the SARFAESI Act, your Lordship. Now, taking this to be an urgent thing because of early hearing, I don't feel your Lordship
should interfere, because your lordship has taken this, admitted it. This is a totally different between the, though he was the plaintiff, judgment was in his favor, against which the state has filed this present application on appeal, first appeal, which has been admitted and it's ready for hearing, no doubt. But fixing it on the basis of these two documents, saying that there is an urgency, when the alternative remedy for seeking a relief before the DRT is already there. That is my humble submission, your lordship, because whether this judgment of this RFA filed by us will
Have any impact on?
impact on a 13-4 application notice issued by the bank, because this is a roost, because this is something a person seeks when there is a sickness. I would admit everything. I will not object on a genuine thing, but these are the two grounds. A notice under 13-2 was issued, against which it was the mandate.
What is the issue in the connected RFA?
The appeal, your lordship.
In the appeal,
Appeal is against a judgment passed by the learned trial court in favor of the appellant, your lordship, whereby,
your favor.
sorry,
Respondent.
the respondent, your lordship, it's not my favor,
Decreeing this rule.
against the state, PWD.
What decree was passed?
Money decree.
Money decree.
How much?
It was quite a substantial amount, your lordship, and against which a deposit has already been made before the trial court on the basis of the apex court order, because interim order was not granted initially out here, stay, and the
50% you have deposited.
Stay applicant, we had filed an SLP before the apex court. Apex court had directed us to deposit a substantial amount of the awarded amount, which has been deposited before the trial court, which is the civil judge senior division number 2. And that amount is lying there, and they have been given the liberty to withdraw the same by filing the necessary security, your lordship. I don't have any other thing, your lordship, but whether a surfacing notice,
Surfacing notice is in respect of what matter?
this is a totally different, I do not have any idea with regard to that, your lordship.
And in money suit, why money was due from you on
This
what
is a contractual matter, your lordship.
contractual? Okay.
Contractual dispute between the
Yes,
PWD
Mr. Alam.
department and the-
May I please?
Yes.
Lordship, with all respect and regard, my lord, I have not been seeking any adjudication of this annexure 1 and 2 in this appeal, my lord. This appeal has arisen out of my lord judgment and decree passed by the London trial court, declaring the suit in favor of the respondent for rupees 2.98 crore, my lord. My say before your lordship, my lord, in this IA, I have executed the contract in question, my lord, by taking financial assistance from the Punjab National Bank. In view of default in repayment, sufficient proceeding has been initiated, my lord, against me, wherein my residential house has been mortgaged. Now they are at the verge of throwing me out of my residence, my lord. That's why this is the urgency involved in this appeal, my lord. As this application has been filed. As far as, my lord, the question of my lord deposit, my lord, there was an SLP filed by state, my lord, before the FS court, wherein, my lord, the appellant was directed to make a deposit of substantial amount of the decree, with a direction, liberty to the appellant to do the same by furnishing bank guarantee. My lord, nowadays no bank is used to issue bank guarantee until and unless 100% security they receive. I don't have money, my lord. I'm not in a position to withdraw the money deposited by the appellant before that.
Because of that bank guarantee.
Bank
clause.
guarantee, my lord. Banks are not issuing any guarantee without taking 100% liquid security. This is my hurdle, my lord. I'm going more than crores of rupees, my lord,
When do you want it?
as per convenience of the Supreme Court, my lord. But
Furthermore,
I'll
your-
leave
your-
your
one thing-
lordship to decide with regard to the taking it outside the rooster, because we are not that. We have deposited, the state has deposited the money. But a surfacey case, he could have got a stay of this particular order. He said that his house will be there. Section 17 permits them for seeking a stay before the DRT, your lordship. Why he has not challenged it? It was in 2000. Instead of pursue, how can they be so sure that my appeal will be dismissed and he is going to be entitled to this? Instead, he could have.
He's hopeful.
Hopeful, my lord, I'm hopeful.
He's
my lord.
hopeful.
My lord,
Actually,
Lordship, my lord,
the-
challenging any
but
duties of
I
service. my lord.
understand hopefulness, your lordship, but when in section 17 power is there before the DRT, assailing and step taken by a secured creditor under 13.4, why he is not exercising that
How
power?
much is due to Bank Punjab
Thanks.
National?
Thanks, you, my lord, is
So is it your case that if you get the decretal amount, you can pay out of that amount? too?
I will assign the degree in favor of the banker, my lord.
Whether
Provision
he,
of assignment of degree is there, my lord.
Otherwise,
Assign the degree.
being appellant, the state may not have any objection.
My lord,
in
your
early
lordship,
hearing.
your lordship, I cannot to see why, my lord, I have been compelled to file this application. Your lordship, I cannot see order dated 3/12/25, my lord.
Page number?
3/12/25, order, my lord, order sheet of the estate appeal. Instead, IA, my lord, IA,
Yes.
3796. Order dated 3/12/25.
Yes.
May I read, my lord? Mrs. M. Das Dalal, Standing Council PWD submits that she has already filed an objection today, but the same is not on record. Your lordship may kind of to take a judicial note. My lord, this matter was listed 3 days back also, on that day also, and today also, my lord. I have obtained requisition from the bench, my lord, for taking the objection. But this is not available before the registry because this has not been filed.
no, it has been,
Not filed, my lord.
I have been
No.
given us from the engaged counsel who has engaged me. I don't
Requisition
know.
was issued from this court for
It is
taking
there.
the same, my lord. This is not there in the registry. All along they have been playing Bukhari with the court of law.
It was there.
This has compelled my lord to file this application for early hearing.
It is message.
Heard Mr. N. Alam, then counsel for the applicant.
24/11 it was filed.
Also heard.
Show the filing.
Filing number is there. ATI is there.
This is the refusal of the registry that no such.
The document number is 16 of
Give me an
25. It has
item
been
number.
filed. Date of receiving is 17, this.
17/12.
Also heard
Next
Mr.
date is 17. Date of registration 24/11, next date of.
Your name is A. Das.
Yes, my lord.
A. Biswas.
A. Bishwas. Also heard Mr. A. Bishwas. You are standing counsel,
I'm not, I have been engaged by special engaged, I'm not by standing counsel.
learned counsel for the respondent sides. This interlocutory application has been filed by the applicants who are the respondent in the connected regular first appeal number 5/2025, praying for expeditious hearing of the connected regular first appeal number 5/2025. Learned counsel for the petitioner has submitted that the present petitioner is the decree holder in title suit number 362/2014 and the respondent slash state was directed to pay an amount of rupees. How much was the decretal amount?
Still amount, my lord, 2 crore. 2,98,76,518.39. That is, my lord, that is 32 of the memo.
Decretal amount of is 2 crore 98 lakh
76,518.39.
39.
Along with interest at the rate of 6% per annum.
He, however, submits that the state respondents have preferred the connected regular first appeal number 5/2025, in which a stay was granted on execution of the decree obtained by the present petitioner in title suit number 362/2014. Stop. He further submits that though the stay was granted subject to payment of how much, 50%?
50% of the.
50% of the decretal amount in pursuant to the order passed by the apex court in the SLP preferred by the
Present appellants.
present appellant, respondent appellant. However, and though it was also provided that the present petitioner can take that money, however, the condition was imposed of furnishing bank guarantee of an equal amount by the petitioner. Learned counsel for the petitioner submits that the petitioner is unable to furnish bank guarantee, and therefore the money deposited by the respondents, state respondent, cannot be taken by the present petitioner in spite of cannot be taken by the present petitioner. Stop. He further submits that in the meanwhile, in a proceeding before DRT.
No, my lord.
They
We
have
have not, I am not, my
Oh.
lord. Well, I am not in a position to challenge this SRPC notice, because for the purpose of challenging this, being a borrower, I am also required to make deposit of 50% before the
Okay.
DRT in favor of bank guarantee.
Further, क्या लिखा last line? In the meanwhile, the Punjab National Bank has issued a notice under section 13 within bracket 2 of SARFAESI Act 2002, demanding the payment of rupees
31 lakh.
31,67,567 within 60 days of the said notice, failing which action under section 13 within bracket 4 of the said act would be initiated. Learned counsel for the petitioner submits that in view of the receipt of the said notice by the petitioner, it has become more urgent to
13-4 notice, they have already taken action. Your Lordship. Annexure 11, page 11.
Pursuant to this, my lord, the bank has already initiated proceeding under section 34 in Annexure 2, my lord.
no, stop. Learned counsel for the petitioner further submits that on failure of the petitioner to comply with the notice under section 13(2), the Punjab National Bank have already initiated the proceedings under section 13
4, Your Honor.
within bracket 4 of the SARFAESI Act 2002. He submits that under such circumstances, the urgency of expeditiously deciding the connected regular first appeal, where the petitioner is the decree holder, however, due to his inability to furnish bank guarantee, he is even not capable of withdrawing the money security deposit made by the state respondent as a condition of stay of the execution of the decree in title suit number 362/2014. Stop. On the other hand, Mr. A. Bishwas, learned counsel for the respondent, has submitted that the grounds shown by the petitioner in the interlocutory application do not justify in itself an order of expeditious hearing of the connected appeal inasmuch as the notice under section 13(4), which is appealable.
Under section 17 of Surface
Notice under section 13(4) of the Surface Act is appealable under section 17
17 of the Surface.
Surface Act, and therefore
The DRT court,
before the DRT Guwahati,
subject to deposit of 50%.
and therefore the petitioner has alternative remedy without pressing for out of turn listing and hearing of the connected appeal. Stop. I have considered the submissions made by learned counsel for both sides. On perusal of the record, it appears that though the connected regular first appeal has been filed in the year 2025 itself, however, considering the circumstances as submitted by learned counsel for the petitioner regarding his inability of even withdrawing the money, even withdrawing the portion of the decretal amount which has been deposited by the petitioner, state respondent, as he is unable to furnish any bank guarantee as stipulated in the order.
Order is dated, my lord, 20th January 25, not honorable apex court, my lord.
Order dated
20th January
28 January 20 January 2025 in
civil appeal number
civil appeal number
842 of 25.
842 of 2025. Stop. To be a, not stop, to be a good ground which requires the connected regular first appeal to be heard and disposed of expeditiously out of turn. So accordingly, this interlocutory application is allowed and the registry is directed to list the connected regular services. Everything is complete.
And the
Regular second appeal, regular first appeal number 5/2025 for hearing. Choose a date, Mr. Vishwas.
we need it after the Bihu.
Before
Putul.
immediately after the opening.
It may not be possible.
No, after Bihu.
I have to be there now.
3rd of February. February.
Yes, sir. 3rd of February it would be.
Right, my lord, if possible prior to that. Last
Bihu,
after Bihu, my lord.
Bihur Pisot,
After Bihu, any date, my lord.
hearing date. Demo.
20 তারিখ
20 তারিখ দিন,
20 জানুয়ারি মনে থাকে তুমি 22 তারিখ
22
22nd January.
22nd January.
My lord, only one correction, my lord,
2026.
this appeal was filed in the year 2024, my lord.
RFA.
RFA 5 of 25 was filed in the year 24, my lord. Due to delay, it was registered in the year 25.
Okay.
Because of the delay,
Delay,
it
my
got
lord.
registered.
I'll make necessary corrections.
46. Much more.
Made this all okay. That I ask for condonation of delay, madam. The notice will go, madam.
Heard Mr. S. Das, learned counsel for the applicant. This application under section 5 of the Limitation Act has been filed by the, how much delay is there?
404 days, madam.
has been filed by the applicant for condoning the delay of 405 days in preferring the connected testamentary appeal. Connected what appeal? Regular
Testamentary appeal, Madam.
testamentary appeal, whereby the judgment and order dated 1/9/2023 passed by the Court of Learned District Judge Sonitpur in Miss within bracket probate case number 11/2022 has been impugned. Issue notice to the respondents. The petitioner shall take steps for issuance of notice upon the respondents by speed post as well as by usual mode within 7 days from the date of this order, returnable after 4 weeks.
Highly appreciated.
47. Please, Your Lordship. Lordship, this matter has come up for the first time. At this stage, will be allowed to issue notice.
What is the matter?
So it's regarding the claimant, we are representing the insurance company. In
This is this is a delay condonation
Yeah,
application. Heard Mr.
sure.
S. Sharma, learned counsel for the applicant insurance company. This application under Section 5 of the Limitation Act 1963 has been filed by the applicant for condoning the delay of 16 days in preferring the connected MAC appeal, whereby the judgment and award dated 19/7/2025 passed by the Motor Accident Claims Tribunal, Bongaigaon in MSC case number 1991/2025-2015 has been impugned. Issue notice to the respondents. The petitioner shall take steps for issuance of notice upon the respondents by usual mode as well as by speed post within 7 days from the date of this order, returnable after 4 weeks. Finish.